Hey, good evening, everybody. Hello. Sorry, a couple minutes late. It's Friday, though, really. It's Friday. So, yes, it is Friday. Welcome, everybody. Something I thought we were going to get to a little bit later, but I ended up having some free time this afternoon. Started reading through it. It's the Fair Debt Collection Practices Act and what happened with Joe in his case. Because, at first when I was, earlier in the week and like Sunday, somebody's like, and I will be, just so you guys understand, when you guys start like, oh my God, you see this thing out there. I'm like, you guys come across like loons, because at this point you already know a bunch of a story and you're just like shoving it in my face at 500 miles an hour. But yes, in the time I've had a chance to read it, I haven't had a chance to read all the depositions. I know there's depositions out there. I have not gotten to them. I've gleaned like bits and pieces of it, but I have read the filings, at least the relevant filings, and we're going to take a look at them. And if you guys weren't aware, the Fair Debt Collection Practices Act is no joke. It is really, really bad. And it's not only that, but this is a great example of, if you fuck up and something doesn't work right, there's something to be said about taking your L early instead of wait until later, because eventually the L becomes bigger and bigger and bigger and bigger. So I want to say hello to everybody, and we'll give everybody another minute or two before we get started. In the meantime, I did want to point out our two sponsors for tonight: the dragonstreasure.com, haven for tea and anime lovers. And you can use the promo code criminal and you get 10% off on all your teas, coffees, and other things you'd like there. I think he's doing jerky too, I think he said now. So there you go. In the middle of in addition to that, our other sponsor for tonight is maf-arms.com. Yes, MAF Arms, also might know them better as Fudbusters, the purveyor of fine wind chime supplies and wind chime equipment out of South Central Florida. If you guys use the promo code POTCRIM, you get 10% off your wind chime orders. So definitely look into that. There's all kinds of wind chimes: plastic wind chimes, metal wind chimes, wooden wind chimes, all kinds of wind chimes down there. Take a look. There might be something you like. You do need me some wind chimes, yes. Can any content creators just be normal? I mean, well, no, we're not all normal. I mean, we're doing this. I mean, let's be real. It is what it is. All right, guys, we got quite a few people here. We're going to get started. We are going to get started now. So, you guys know Joe Neerman, Good Logic. And I know this because Joe's mentioned it before. His primary focus when he was doing, I think he still practices too, but he's kind of scaled back from that to an extent. His primary practice for a very long time was doing civil litigation and debt collection, which, Jew jokes aside, is a part of law, because you do need, eventually at some point, you will need attorneys to get involved to help secure debts. Because, okay, the person won't pay you. Now what? Well, you have an option. You can sell that debt to someone else and you'll sell it at a loss. So somebody will buy your debt for 30, 40% of the value. You recover some money, and then their job is then go attack that debt. So what do? Well, they use various methods. They might seek garnishment of your wages. They might file suit in court. They might do a bunch of different things to get your debt. And one of the other things they can, when they file suit, they have to follow rules. Even when they're just calling you, they have to follow rules. Anything they're doing regarding the collection of debt, they have to follow rules. And federally, that is governed by the Fair Debt Collection Practices Act. It's a law that's been around for a long time. It's not brand new. It's been around since like 1977. It's been around forever. Now, you guys might say, well, it's the Fair Credit Reporting Act. That's a separate thing. Like I said, this is a 5-letter act, the FDCPA. And it limited a lot of things, because up until the law got passed, You could get calls at any time of the day or night. It limited how long you could. Hold on. It limited how or often you could be called at home. You couldn't be called at home before. Now it's like 9 a.m. and you can't be called after like 7 or 8 o'clock, your local time. Otherwise, before that, they could call you all the time. They could call your place of employment. They could try to harass you that way. They could talk to third parties about your debts. They could do all kinds of crazy things. They could just, they call you and it just ring, 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 and they just let it ring forever. And think about it. Back before this, the 60s and 70s and before that, people didn't necessarily have answering machines. Those were a luxury item. So they keep the phone ringing and ringing and ringing and ringing. So even if you took it and hung it up, they call right back and let it ring and ring and ring and ring and ring. They did a lot of different things like that. They would publish bad debt lists of like people who had debt. And like, they publish like a deadbeat list in like papers and in publications. Now, it wasn't like the New York Times, but it'd be like your local newspaper. Or how you get like your local newspaper, there's like the mugshots thing. You'd have like bad debt list. Or they'd put them up and put them on telephone. They could do whatever they wanted. There weren't rules on it. And some of you might think, well, that sounds base, or that's a way to, shame people into paying. Yeah, I guess. They could call you. They could threaten you. They could berate you and swear at you. They could threaten legal action, whether or not it's true or not. Now, that's kind of one of the big things we're going to be talking about. A lot of things they could do. They could use embarrassing media. They could use like postcards. And, think about today, they could do stuff where they could probably put you on like TikTok or try to read you through TikTok or do all kinds of things like that. Well, that's all forbidden by the Fair Debt Collection Practice Act. It creates a lot of restrictions on debt collectors, and it imposes a strict liability standard. And the strict liability standard is really just that you are responsible for it, and it doesn't really regard of your intent. It's just like you did it. There's no fault. You just did the thing. Okay, well, you're fucked. Now, there are a couple of things where a creditor can say like, look, I really didn't do this. It's really not my fault. And there's like a handful of situations where they can get out of it. They're very, very limited. You have to show like a bona fide error. And the reason why those are so rare is there's a lot of procedures and things you have to do to make sure that debt's good to go before you go pursue it. And you should be doing that. Fallen Preacher says, oh, I finally get the joke about wind chimes. Well, I'm glad you finally got it. But there's other things you could do with it. One of the bigger ones is don't call me anymore. Don't talk to me unless you're going to pursue legal action against me. Now, a lot of debt collectors aren't going to pursue legal action. It costs way too much money. You're one of like 10,000 people they're shaking down for money, and they're hoping a couple of you pay up. So that is the option they could do there. So, yeah, there were a lot of different things about that. So, and this is kind of like, the revolution of people having rights because corporations had rights. Well, people have a chance, the government had to step in. There is strict liability here. There's statutory damages. You could sue for attorney's fees. And as we'll see here, there's other things you can sue for. And we're going to get to that. By Franz, yeah, they call you at work. This is actually when I was in a class about debt, the professor was an old guy. He talked about this, like when he was in law school, you'd hear the stories. They call you, you'd be at work or something, and they'd say, hey, Bob, hey, your wife was in a car accident. You need to come take the phone. And they pick it up. It's like, hey, sir, this is so-and-so from the debt collection agency. Pay up, you cocksucker. They would do shit like that. They do shit to people while they're in school. They do all kinds of things like that. They did a lot of stuff. So this is all set. There's rules, there's procedures. And now you could still, people get their debts, debts get collected all the time. It's because corporations and groups follow the rules. Vanguard King points this out. Yeah. The previous owner of our phone number owed so much money, our phone rang so much you couldn't dial out. That happens. It's just like the song Shaniqua don't live here no more. People call and looking for Shaniqua. She don't live here anymore. It happens. It happens. So Joe's situation here. So here's what we know, and here's how this all started out. A guy known as Shoal Levy, however you want to pronounce it. This is some Orthodox Jew internal struggle stuff here, it seems like. Yes, as Tyler Yankee said, it's Jew on Jew crime. It very much is what it sounds like. So it's a guy named Levy, and guess where he lives? Miami Beach, Florida. You're like, okay, that's, once again, we're doing great on the stereotyping already. Guy named Levy who lives in Miami Beach, Florida. All right. So it's a subpoena ducis tecum, meaning it's a subpoena for you and your papers. And it says in the civil court of the city of New York, county of New York. And I talked about this before, guys. The county of New York is Manhattan County. Okay, that's Manhattan Island. It's actually a county in and of itself. All 5 of the boroughs are their own counties. There's Brooklyn County, Queens County, Staten Island's its own county, Yonkers. They all, in the Bronx, they all have their own county, Yonkers, but like, hold on, Manhattan, Queens, Brooklyn, Bronx, Staten Island. Yeah, sorry, Staten Island. There we go. Staten Island. They all have their own. They have their own district attorneys. They have their own county governments. Then they also have the overriding city government. It's a very interesting setup they have there. Oh, Brooklyn's Kings County. My bad. Sorry. But yes, they have all their same. They have their own counties. Okay. They all have a county. It's all a county government. So that's why you see the county in New York and you're like, well, where the hell is New York County? It's Manhattan. But yes, thank you, KLF. Yonkers is not America. Yeah, fair enough. Anyway. So, and this is a subpoena, okay? And it's a greetings, whereas a civil court of New York, in the county of New York, between Matt Morrison as plaintiff and Shoal Levy as defendants, were the parties to this action. A judgment was entered on 3/11/2010 in favor of the plaintiff / judgment creditor against Shoal Levy. The defendant residing at 575 Collins Avenue in Miami Beach, Florida, and the total sum of $8,700, of which the sum of $13,990.08 remains undue and unpaid. Okay. And therefore, pursuant to the civil rules of New York, you appeared to attend before recovery of judgment, and that is a company, a debt collection company, at 39 West 29th Street in New York, New York, on December 26th at 10 a.m. Now, for those of you who are like, that's a day after Christmas. Yes, that is a federal court, and that's a federal holiday, a court holiday. It's a holiday recognized at every level of government. Why isn't that not a problem? Well, let's be real. If your name's Levy, you're probably not worried about Christmas. And if you're Joe Neerman, you're not worried about Christmas. With that being said, everything else is closed. I think this is already the first big problem. Doing it on a day like that, that's just bad form. That's just bad form. You're supposed to do, subpoenas like this, things like this, are supposed to be served on people for business hours during a business day. So yes, the 26th of December in 2010, I'm sorry, in what year? Hold on, what year is this again? It is a valid thing, but it's a Monday, but it's a court holiday. Well, why wouldn't you just do it on the Tuesday? or whenever. But then you also have issues serving subpoenas on people. You can only have that subpoena be valid and tell them to show up. You can't have a subpoena saying, hey, you need to show up tomorrow, and it gets to them the day before. They have rights to have it so many days beforehand, or it's not valid service. There's a lot of issues serving subpoenas on people. That's why there's a whole set of things on quashing subpoenas, getting them tossed, for a multitude of reasons. Anyway, they want them to show up for the taking of a deposition under oath upon oral or written questions on all matters relevant to the satisfaction of the judgment. And satisfying the judgment means getting paid. So they command you to produce information of your bank accounts that you've maintained in the past 5 years, financial statements, all federal tax returns, and all deeds of real property owned by you. And these calls it debtors examinations. And you have to, they can subpoena you to bring this stuff. Figuring out what you own, how much money do you actually have? Certificates of title and registration for motor vehicles, stocks and bonds of broker accounts, money market accounts, life insurance policies, where you are insured or your beneficiary, securities, bonds, notes, and mortgages owned by the debtor. So if you own debt yourself, well, they might want that, and you can satisfy your debt with debt you owe from other people. Stocks and commodity contracts, any broker and credit balances maintained by a debtor, any loans by the debtor. Because, well, I don't have money. Well, show us why. Prove it. Accounts receivable, businesses owned. The cash surrender value of life insurance policies, any vehicles, any real estate, any vested interest in trust, any contingent interest, prospective inheritances, things like that, where you're not guaranteed it, but there's a chance you might be involved in it. Household furnishings, jewelry, art, antiques, or precious objects, any other assets. And they talk about all the different things here. Credit card statements, statements for utilities and gas, any documents related to help people understand whether or not the debtors could realize a potential gain from it. I mean, when you get to these situations, kind of like bankruptcy court, guys. Share the screen, sorry. This is the stuff, like when you're in bankruptcy court, you have to show a lot of things. It's not this intensive to an extent, but it's still quite similar. You're showing why I can't afford to do this. Okay, well then show us what you have. Oh, you own all these properties. Well, guess what? The court can order you to sell them. Or you own this, or you own these accounts, and you own all these assets. Luke says it's stark when you list all these possible assets. Damn, yeah. Yeah. This is not abnormal here. And then it's just any and all the books, papers, and other shit out there you may have. It boomered again, I'm sorry. 2.0 is busy right this second, so that's why she's not there. So, Parallax says share screen and remember my chat. What did you say something here? Hold on. Oh, we'll get to your comment. Parallax. And it says, take notice that false swearing on such examination or failure to comply with the subpoena is punishable as a contempt of court. And that's true. If you fuck around in this, you could be held in contempt of court. 100%. 100%. That is true. That is not an incorrect statement of law. And as contempt of court, the court could punish you. It could give you monetary fines. It could give you sanctions. Civil contempt also could theoretically lead to jail, but that's like almost, you've got to be swinging. You got to be shooting for the stars at that point. It's really hard to get civil contempt and land you in jail. But it has happened. It does happen sometimes. Okay. And it says a restraining notice. You are hereby forbidden to make or suffer any sale, assignment, transfer, interference in any property in which you have interest, except upon the direction of the sheriff or pursuant to an order of the court, until aforesaid judgment is satisfied or vacated. And that's another thing. If you're under examination for all this stuff, Without permission of the court, you can't sell property. That doesn't mean you can't go buy groceries. But if you have a $15 million penthouse, you can't just, I sold it. Sorry, it's gone. Ha ha ha. Oh, the money's gone too. No, it's the similar way if someone sues you and you get rid of all your shit. And you're like, oh, sorry, I lost all my assets. Well, no, the court could say those are fraudulent sales. Yes, it's punishable as contempt of court. Yep. So they talk about, and this keeps going here. This is another thing here. It's prohibition of transfer. You can't transfer property, and this goes on and on and on. That when you have reason to believe that there's an interest that you could use to satisfy the judgment, you can't get rid of it. The only thing where you can do stuff is to like your child support collection unit. So if you owe child support, you have to pay that. That's one of the few things, because remember, the government's involved, and the government doesn't give a fuck about you, but the government wants to get paid and make sure that it's paying out your money instead of tax money to people, to your baby moms. So, and this was signed by Joe Neerman, Esquire, attorney for the judgment creditor, and his, I think it's Joe's company, or it used to be his company, Recovery of Judgment. And it's over on 39 West 29th Street, Suite 612, New York, New York. And this was done on December 10th, 2016. So this is the thing that showed up here. This is what showed up. And this is known as Exhibit A. Attached to this was Exhibit B, which is from the law offices of J. Henry Neerman, which, if you guys aren't aware, that's our boy Joe. Joseph Henri. Maybe he's a French Jew. Henri. So it's obviously the same address. And notice, it says it's the law offices of, Joe Neerman, but it has recoveryofjudgment.com listed, and then it has support at recoveryofjudgment.com on an email. And then you look at these numbers here, the 646, and that is a New York phone number, 863-9783. Well, let's go back to the other one, and what does it say? It has 646-863-9783. So it's very easy to establish from here Joe and Recovery Judgment are one and the same based upon that. And that's not really ever been an issue, but I'm just, when you guys are looking at stuff, it's very easy to piece that part together. It's very easy to piece that part together. Does anyone dial that number? Oh. Maximum opacity. Can you guys not read that? Okay, I'll turn it down some. I didn't realize it was there. Is that well, it's almost not visible. Is that easier to see, chat? You guys are saying nope, that's not helpful. We can read fine. JREC is old. Okay, well, I just want to make sure you guys can read it because it is critical to see what's going on here. Now from here, remember what I said, guys, you can't threaten people. Okay, well, the judgment entered, and this is 6 years later. So guess what happens while you have a judgment entered? The juice is running. The interest is running. So that $8,000 debt just gained like $5,000 attached to it. It's been sitting for a while. So once again, this is served on, Levy down in Miami Beach, Florida. And this is a letter just attached, and this would be accompanying it, saying, hey, look, here encloses subpoena ducis tecum, directing you to appear for a post-judgment deposition on December 6, 2016 at 10 a.m. and turn over your financial information. This part's fine. This first issue is fine. These financial documents include tax returns, bank statements, and other documents as detailed therein. Makes sense. Pretty cool. Please take notice that failure to comply with a properly issued subpoena entitles the creditor to move the court to impose sanctions on the debtor and request additional fines and or imprisonment. Now we're getting to a problem here. Now we're getting to a problem. There's another issue here. And this is from, very truly yours, Joe Neerman, as legal counsel. So, and what do we notice on these documents that's kind of scribed through them as a watermark? And as Nick says, chat, it's all about the watermarks. My watermark, chat. There's a watermark. No. So there is a watermark, though. And what does the watermark say? Well, the watermark says final notice. And then when you go back to the one we just looked at, the actual subpoena that was served. Oh, God, that's not right. You need to do that in the other color. Final notice. Okay. Is it really the final notice, though? Is it really the final notice? I don't think so. And there's no indication there were other notices. Now, I'm not drawing dongs. So where are the other notices? So what did this Levy guy do? And I think it's clear this, the allegation is this Levy guy owed rent and he didn't pay it. So people went to court and they pursued it. And now there's this outstanding judgment. And then, Joe buys it for, pennies on the dollar and then takes it and he goes and chases it. The next thing that got filed, and this is another exhibit that was filed, is this from the district court, the civil court, the city of New York. And now this is where things get fucky, chat, because now we're running into a situation here. And, we're kind of very much at a which way. We're at the which way tree. For those of you who are Texans. So it's a decision and judgment. And it's Levy, Scholl guy, Charlie guy, Charlie Levy, and Scholl. So it sounds like this guy, the way this is written, sounds like this guy's a bit of a scumbag. So it wouldn't be an issue there. So anyway, decision and judgment is rendered and based follows. Judgment of possession is granted in favor of Matt Morrison and Andy Yen. Okay, a money judge. So judgment of possession. So it sounds like this was housing court based on that part alone. A counterclaim is granted in favor of the person respondent of $0 because he never filed a counterclaim. A money judgment is granted of $0 in favor of Morrison and Andy Yen for a total amount of $8,700. The monthly use and occupancy is set at, and that should give you another hint, guys. This is housing court, so it's a rent thing. And it says the warrant to issue forthwith. The date is March 11, 2010. And it was done by Brenda Spears, judge in the housing court. So it's a civil judge in a housing court. Okay. Now, here's the thing, guys. This apparently never exists. That's the thing here that's fucking weird about this. We're going to get to all this later. But this thing is... Yes, we can see your chats. This whole thing apparently doesn't exist. Now, is it just it wasn't filed properly? Maybe. Is it possible this entire thing is faked? I mean, if you fake this, faking a court document is forgery, among other things. And that'd be a felony. Like, that's not good. In addition, there's, professional responsibility issues. That's why this whole thing is just fucking weird. So, anyways, Levy gets this and he goes and checks out this case number and he gets an attorney. He does the smart thing. He goes and finds an attorney. One more thing that had been filed, and this is an assignment of the debt. And guys, this is all it takes to sign debt from people. It's not a very super induced, it's not a super elaborate process, but you take these guys. So it's the first guy is Matt Morrison is an individual from California. And on March 10th, he got a judgment in favor of $8,700. Okay, so that happens. And then we find out in April of 2010. So about a month later, there's a signing it over of it. And this is actually very standard boilerplate language for, if you ever look at deeds, you'll see this part right here. So for $10 consideration, and guys, consideration is what you do in a contract when you're buying or selling something. So in a contract, it's the bargain for exchange. There's an offer and acceptance. Well, just like land, there has to be consideration. It has to be done for value. Love and affection is not a value. Love and affection, or just a handshake, or because you're a good bro. No, doesn't count. $10 consideration. Now, did they just pay? Did they Joe give him $10? This guy $10 and say, okay, here's my $8,700 debt. No, there was probably like whoever owned this debt took a haircut on collecting the full amount from Joe, and he's like, here, I'll give you 20% of it, or a lower percentage of it, whatever it is, guys. And they said, okay, cool, fine, here, we'll sign it. So this amount was a lot higher than $10. It was going to be a lot higher. But for that consideration, receipt of which is hereby acknowledged, I hereby assign all right, title, and interest in the judgment to Recovery of Judgment, LLC. Now, this is a very basic thing, but this is what you'd see. Like, I hereby assign all right, title, and interest in this parcel of land to Meme Copium for this $1 in valuable consideration. That's why here in Ohio, when people sell their cars and you sell a car, what's the value of the car? $1. That's all it takes to show it's got value. Because you put down zero, they're not like, then you're really fucked. But then you say, notice this instant assignment has been served upon the judgment debtor via forwarding a copy of this instrument via first-class mail to his or her last known address, being said 635 West 42nd Street, apartment 19D in New York. That's the other part of this. You have to send on that debt notice and that assignment to other people, including the debtor. He has the right to know, well, here's the guy in charge of it now, because let's say this guy wanted to pay it. Now, presume it's real. That guy wants to pay it. Well, he has to know who he has to pay. So it wasn't just for $10, guys. I can tell you that much. It would have been for a little bit more, but obviously they're not getting all their money. And then it was notarized here in the state of California. And there's a notary signature. There's Matt Morrison. He signs it. That's a little fucking weird. That's a signature. You're an adult man. Actually have a real signature. So anyways, this is an effective assignment of debt. That's all it takes. And then the next one that was attached is the assignment of debt by Andy Yen. Because remember, there's two people on this. So both parties have to be involved. Now, Joe could keep 50% of the debt, and he could split it between Andy Yen at that point. Or he can just go to Andy Yen and say, here, I'll pay you too. Give me all of it. That's the other option. So the other guy lives in California, in San Francisco, and he resides at, they reside in the same place, which you say what you want about that. And they had a similar thing here, and it says, once again, for $10 consideration, I hereby assign all right, title, and interest in the judgment for $8,700 to Recovery of Judgment, LLC, who at the time their address is 2152 Ralph Avenue. Ralph Avenue! It's just like we find out about Chief Felt. It's like, Ralph Avenue. I'm Bill Church on Ralph Avenue. Suite 1 in Brooklyn, New York, 11234. And once again, they forwarded this on to the guy who's allegedly supposed to owe the debt. It's signed off here. And then once again, they went to the same notary at the same time, probably one after the other, and Andy N signed it. So at that point, if this was a valid and effective debt, Joe would have the debt. Yes, Eric is saying it's not true. Yes, that's correct. That is correct. So there's this part. If this part was legitimate, if the debt was valid and all of that, you could assign debt. You guys can go out there and buy debt. And like you literally could do it yourself. You could go out to people and buy their debt. If you happen to have a friend who's a dentist and you might have debt from people who owe bills, you could say, hey, I'll buy your debt off you. And he can assign you your debt right now. There's no formal things. You don't have to have special permission to hold debt. You know, you can hold debt over. You can take other people's debt and buy it up and then go collect on it yourself. It's not something I would ever fucking recommend doing. Don't do it. But you could if you wanted to. Eric Holmes says cred maxing. Yes. Ag says, yay, unregulated debts. Well, most debt's unregulated, man. Like, yeah, there's mortgages and stuff, but most debt's unregulated, dude. Think about people owe credit card companies and shit like that. That's unregulated debt, unsecured debt. So, with all that being said, he hired attorneys. Shoal Levy hired attorneys. And they filed a complaint. Because one of the things you can do under the FDCPA is file a lawsuit. So they filed a lawsuit. And they filed a complaint. And they filed in the United States District Court for the Southern District of New York. Now you're thinking, why would they do that? Why would they do that? Why would it matter? Well, Sweet Tooth Fairy saying, yes, easier to write off debt. Yes, at times it is. But yes, against the law offices of J. Henry Neerman. So it's listing the, because remember, guys, if you go back to the beginning of this, why are you doing against the law offices? That might be a separate corporate entity. Might be an LLC. Might be a partnership. Who knows? But here's the thing. You sue everybody you can, and then you cut the list down as you go. J. Henry Neerman, so Joe Neerman, and then Recovery of Judgment LLC as defendants. Those are the three parties. Now, for all intents and purposes, they're one thing. They are one united front. So this is an action for money damages and declaratory judgment brought for violations of the Fair Debt Collection Practices Act. And you guys see here, it's 15 USC 1692. That's why we're in federal court, because it's a federal law. It's a right of action established under federal law. So that's where you pursue it. You wouldn't pursue a 15 USC 1692 action in a city court like that, because it's not their jurisdiction. But they're also suing under New York General Business Law, Section 349. They're saying this action relates to the defendant's illegal, deceptive, and abusive attempts to collect an allegedly unpaid judgment via a flagrantly unlawful and improper subpoena. That's all this is at. It's that stuff Joe sent out in the mail. Guys, this thing here, the subpoena, and this letter from Joe, this is it. And that's, for want of a horseshoe nail, a kingdom was lost. So they point out, they additionally say, moreover, the underlying judgments we're purportedly attempting to enforce appear not to exist. So it doesn't exist? That's fucking, like I said, this whole thing is fucking crazy. Like, I don't understand how you just mistakenly, I have this judgment. Because we'll go back to this judgment from the court, guys. This is a valid court. Like, I've reached out to some people and they've said this looks normal. For around 2010, this looks acceptable. Like, this is not weird. This is what it would look like. But anyways, as we keep going with this, wow, I liked my face up a lot. And talk about jurisdiction and venue. Well, jurisdiction is conferred by the Fair Debt Collection Practices Act and also 28 U.S.C. 1331. Declaratory relief is available pursuant to 28 U.S.C. 2201 and 2202. And they say venue in this district is proper because the defendant resides in this district and the acts of the transactions that give rise to the action occurred in this district. So not only, okay, fine, we could try it in federal court, but what federal court? Remember, there are 93 federal district courts in America. Which one do you go to? Well, you have to say why this one's the best one. Not the Eastern District of New York, because the Eastern District of New York is Brooklyn. Maybe it's the Northern District of New York. Maybe it's the Western District of New York. Maybe it's the Northern District of New Jersey, or you're going to try for the District of Montana, or the Southern District of Ohio. Well, you're going to say, well, no, those don't matter because we're not in the right spot. But the acts and the transactions that gave rise occurred in substantial part here. I would argue pretty much in their entirety. So they say the party, Shoal Levy is a natural person who resides in Miami Beach, Florida. Yep, he is a consumer as defined under the Fair FDCPA. The defendant law offices of J. Henry Neerman, Lawn, is a third-party debt collector whose principal business purpose is the collection of debts. Lawn regularly attempts to collect debts alleged to be due to another and is a debt collector as defined in the FDCPA, which is true. Lawn is engaged in the business of collecting debts in New York and maintains his place of business at 39 West 29th Street, Suite 612 in New York, New York. J. Henry Neerman is a third-party debt collector whose principal business activity is the collection of debts. Neerman regularly attempts to collect debts alleged to be due to another and is a debt collector as defined under the FDCPA. Neerman is engaged in the business of collecting debts in New York and maintains his place of business at the Office Recovery of Judgment there on 29th Street. Parasocial audience, is this doxing? No. And J-Rock brings up a very good point. And this is something, once again, that makes me fucking scratch my head. Because J-Rock knows this stuff better than I do, because he does a lot of FDCPA stuff. Why didn't they sue in the Southern District of Florida? Because under the Fair Debt Collection Practices Act, Shaw Levy could have filed this in the Southern District of Florida. Down where he lives. He could have filed it where he lived. Allegedly lives. But instead he came all the way up to New York City, to file it. Once again, guys, there is some weird stuff going on here that doesn't make a lot of sense. I wasn't joking. I know other people have mentioned, yeah, it's some it's some internal Orthodox Jew stuff. It could easily be that. I mean, I've joked about it before, but even Joe's acknowledged it. The Orthodox community is very much a self-regulating community. They, have their own police department. They have not their own police department, but they have like an auxiliary police force in New York City called the Shomrim. Like, they have their own. And it's like, there's all kinds of stuff in really any significant immigrant community. They handle their own business. You'll see, in Muslim communities, they'll agree to try things under Sharia law and have that be binding as judgment here in America. Like, there's all kinds of stuff that happens. All kinds of stuff. Yes, they'll do it in their own tunnels. John Scott says a misplaced comment on a letter could get you sued. Sometimes, yes. Sometimes, yes. And remember, guys, it's a strict liability, meaning, well, I didn't mean to do it. Doesn't matter. So the defendant recovery of judgment is a foreign limited liability company. According to its website, it's a third-party debt collector focused on judgment recovery, as is shown in Exhibit D. And judgment recovery is a debt collector under the FDCPA. It's got the same place of business. As stated above, all three defendants share the same business address. Nearman and loans send to customers and consumers dunning letters that list the same address, phone number, and fax as the address, phone number, and fax of judgment recovery. Yep. And as I pointed out, guys, you see the judgment recovery thing on the loan website headers and on the headers there, and it's support at recoveryofjudgment.com. Upon information and belief, the defendants are united in interest and, in essence, operating as one unified debt collection operation controlled by Joe. And that's true. That makes 100% sense. 100% sense. So they repeat and reallege all the incorporations by reference. So by letter dated December 10th, 2016 and postmarked December 13th. So the letter was written on December 10th and then 3 days later it got mailed. It was sent by regular mail. That's a problem. To Levy and the purported post-judgment subpoena. The subpoena purports to be in relation to a judgment of Matt Morrison versus Shoal Levy. With the purported index number of 056136/2010. And it says for him to show up the day after Christmas, which was a federal holiday. And that's... Subpoena further commands Levy to bring with him comprehensive financial documentation, including bank statements, all that stuff for the past 5 years. Subpoena also contains a restraining notice saying that he can't sell anything or do anything with his property. The restraining notice further states disobedience of this notice is punishable as contempt. The subpoena states final notice in large letters across each page. And the accompanying letter by the law office is signed by Joe, but listing the address and phone number shared with the defendant recovery judgment, warns that failure to comply with the subpoena entitles the creditor to move for sanctions and request additional fines and or imprisonment. And or imprisonment, that's the big one, chat. That's the big thing. And notice they highlighted it, they underlined it in bold. Well, that's the way it was in the letter. The subpoena and accompanying letter are flagrantly unlawful and in gross violation of New York law and the FDCPA. The subpoena and accompanying letter were sent to Levy in Florida, whereas the purported default judgment in question is listed as having been taken in New York. Such out-of-state post-judgment subpoenas are void under New York law, which has no provision for service of a subpoena upon a judgment debtor without the state. They're pointing out that the subpoena is not valid anyway. Even if this weren't so, the subpoena is a nullity because it was required to be served in the same manner as a summons. I mean, you have to be properly served. You can't just get regular mail. Regular mail will not be the valid service with regard to a summons and is therefore not valid service. And that's another option. When you get served with legal documents, the challenge is, I've never been properly served, I don't have to respond. And that is a valid action. If you aren't properly served, you don't have to respond to it. But you have to come in and argue, I wasn't properly served. The subpoena is also improper because it's required to set forth the deposition date that falls during regular business hours. And once again, chat, like I said, business hours are not the day after Christmas. Because it does not qualify. Moreover, the subpoena was not timely as it was mailed at earliest on December 13th and did not arrive until less than 10 days before the supposed deposition date. And like I said, chat, before, you need to have notice. You need time to prepare. There's multiple ways you can attack a subpoena, and this is one of them. It wasn't served properly. You don't give me enough time. if it lacks statutorily required language. And because the subpoena was unlawful, demanding what was in the letter was also unlawful. Moreover, the underlying action appears not to exist, which that is weird. And guys, this case has gone on since 2016 and 17. In the past 6 or 7 years, there's been nothing to establish this case exists at all. It'd be one thing if this was like a railroaded through lawsuit. It happened in 90 days. You can say, okay, well, maybe it's out there, but it's been 6 or 7 years and nobody could find it. Like I said, it's a little weird, guys. By a lot. And specifically prior to filing this litigation, the undersigned sent a letter to Neerman stating that Levy did not recognize the underlying action, saying, I don't know what the hell you're talking about. And subsequently, in a conversation on December 27th, Neerman indicated he would send counsel for plaintiff the underlying court file. Counsel for plaintiff followed up on this request on January 12th. Neerman did not respond. And that's the thing. If you fuck up in court, get out in front of it. Don't try. The longer you hide, the worse it gets. The longer you avoid it, the worse it gets. You got to get out in front of it and deal with it. If something happens, address it and address with the court. You might be able to fix it, or you might be fucked. And if you're fucked, then you deal with it. If you're allowed to fix it, then fix it and move on and keep that in the back of your mind. But just ghosting at that point, that's not a good look. So, after that point, since that time, after conducting initial research failed to identify an underlying caption, they went ahead and they conferred with the New York Civil and Supreme Court clerk's offices. Guys, remember, the Supreme Court's not like the Supreme Court. That's the local level courts. The clerks could not find and identify such an action in their databases. And based upon this inquiry, and it's fair to make the argument, I asked the clerks, and there's no record of this case ever there. Now, let's say it happens, it turns out it's 56137. Because let's say you type in 136 and it doesn't exist. Okay. But let's say it's 137. Boop, fixed. Okay. Well, Joe's still there because that's not a proper acknowledgement of things. But then you could say, okay, yeah, that was an accident. You're off by 1. But this doesn't exist right here, guys. This doesn't exist. And they say the plaintiff hereby alleges the underlying judgment does not exist. And you're like, oh boy. Oh boy. And the alternative, the underlying judgment has been materially misstated in collection communications received from the defendants. Now, I talk about the first cause of action, violations of the Fair Debt Collection Practices Act. Now, they point out what are the actual violations here. Well, the first one is falsely representing the character, amount, and legal status of the purported debt. Falsely representing that a judgment had been obtained against him in an action in New York Civil Court. Threatening to take actions against Mr. Levy that cannot be taken and were never intended to be taken. The taking of his deposition in New York, moving the court to impose sanctions, or requesting possibly jail time. Making false representations and deceptive means to collect or attempt to collect any debt or to obtain information concerning Mr. Levy. Falsely representing that documents are legal process. So the big one. Attempting to collect amounts not authorized by any agreement creating the debt or permitted by law. Yeah, because where's the proof this ever existed? Well, you don't have it. Where is the rental agreement or the contract between Levy and Morrison and Andy N? It doesn't exist, apparently. Bless you. As a result of these violations, the plaintiff has suffered actual damages. And they include attorney's fees and costs. Yeah. Aggravation, nervousness, and emotional distress, fear, loss of concentration, indignation, and pain and suffering. As a result of these violations, plaintiff is entitled to statutory damages of up to $1,000, actual damages, and attorney's fees and costs. And the second violation is under New York general business law. And you know what, guys? You sue for everything. And then whatever works, whatever gets dismissed, whatever. But you sue for what you can. So basically, they're deceptive trade practices and deceptive acts. These deceptive acts were committed in the conduct of a business or trade. And it's the attempt to collect a purported judgment that is alleged to have been reduced to a New York State court judgment. It appears that it doesn't exist. These acts were consumer orientated, and they were. The conduct was not a unique one-time occurrence without possibility of replication or reoccurrence. But they say you couldn't do this again is what they're arguing. So they point out the statements of conduct and the attached exhibits were materially misleading by the defendant. And they're saying Joe willfully and knowingly engaged in deceptive tactics, set forth in bad faith and on information and belief, do so on a regular and reoccurring basis. Now, notice, remember, guys, I think it's been said multiple times. You say information and belief, that way you're trying to hedge your bets. It's giving you a little bit of cover. So they point out that they're entitled to actual damages, declaratory judgment, and an injunction. They don't want him sending out subpoenas to consumers outside of New York. An injunction against sending out subpoenas via regular mail. An injunction against sending out subpoenas that fail to accurately and completely set forth the caption of a case. They're actually asking for 3 times the actual damages, up to $1,000, punitive damages, and reasonable attorney's fees. And they list everything they want here, and it's signed by Kalek and Schlanger. So they're asking for quite a bit. They're asking for a couple $1,000s at this point, which, that's not fun. Nobody wants to pay a couple $1,000, but it only gets going from there, guys. It only gets going from there. Things only pick up. And this case drags on for years and years. Remember, COVID was in the middle of this, but this case drug on forever. This case was in litigation hell, I would argue. I don't know what else you would call it. Just litigation hell, just been dragging along and dragging along and dragging along. Now, eventually in 2021, both parties filed a motion for summary judgment, and there was an order about that. And actually, before we get too far, let's check in on what you guys are talking about here. Let's take a look at this. Romeo says, what does a foreign LLC mean? Foreign doesn't necessarily mean out of America. Foreign just means not in that state. So if I'm in Ohio, a foreign LLC could be an LLC in Pennsylvania, but it could also be an LLC in Quebec. So, but generally foreign in this situation means just not within the confines of your state. Yeah, and J-Rock brings up a great point. The moment you get hit with that complaint, you settle. And this is one of the times where you're going to have to settle. It's, $3,000 plus a couple $1,000s in attorney's fees. Maybe $5,000, $6,000. You take your L when it's small. L's grow over time, and this is something attorneys routinely do. I mean, it happens in every business, but you see attorneys do it. They fuck up. They keep hiding, and all of a sudden, it's this big L, and it goes, boom, right on top of you. Whereas if you had taken care of it right away, it's an L the height of a domino, and it goes boop, and it's a pain in the ass, but you deal with it. You grin and bear it. Lochnev Laveau saying, doesn't this trigger double jeopardy? No, double jeopardy, this is a very good question. No. Double jeopardy only occurs in criminal cases, and that's being tried for the same crime twice. He's being sued under a federal theory and a state law theory. So the way this court case could work out, he could lose on the federal claim, he could win on the state claim. He could win on the state, he could lose on the state claim and win on the federal claim, or he could win on both claims. Just in the same way the state of Ohio could try me for murder and the federal government could try me for murder if it's applicable. There's dual sovereigns there, and in a way, when you have that situation, you could get recovery under both statutes. Yes, L's grow exponentially. Oh, we got a Nicholas raid. Well, hello, everybody. Hi. Oh, Tyler, how you doing? Yes, he sent my chat here. Yes. And Tyler, I understand we when you were describing this at the beginning of your show, I thought it was hilarious. You're like, well, it's some Jew on Jew stuff. It's like pretty much. And I think this was like I think there was an internal debt in the Jewish community, and Joe got a hold of it and was like, I'm gonna go get it. And then this Jew drug us, this Jew, Shoal Levy, he turned and ran to the Gentiles for help. It was an internal beef, and he drugged the Gentiles into the fight. And now the Gentiles, the rest of us are like, now we got to deal with this. Oh, I know that's a bit of an oversimplification, but in a way, that's kind of what happened here. And I kind of get that vibe. Maybe if there wasn't a judgment, I'm sure this debt is legitimate. This guy probably does owe a debt to people, but I just don't understand why we're using because I don't like faking this. You could get disbarred for this if this is fake. Faking court process and faking documents, Lord child, is not a good thing. And that's why I'm saying it doesn't make any sense. Would do I think that happened here? No. But you're left with so many questions. It's like, what happened then? What happened? It doesn't make any sense. This whole thing is fucking weird. And I just don't get it. It doesn't make any sense at this point. Is Joe at risk of criminal action? If you made a fake court judgment order, yeah, your ass is grass. That's forgery. You're not allowed to do that. Theoretically, this could be a big problem. That's why I'm really confused. Because if this was an issue, why did they go run to the police with this too at that point? I just don't know. That's like I said, guys, there's so many issues here with this. Yeah, I mean, I'd like to give with Occam's razor here, keep the faith. Occam's razor is a sharp bitch, but she's sharp. So it is weird. It's very fucked up. It doesn't make a whole lot of sense how this happened. Now, somebody asked a question here, and we're going to get to the super chats and things real quick. Soul Wound, you bring up a good question here. Oh, and Loknev, I hope that answered your question. Like I said, that's actually a very interesting. I thought that was a really good question, by the way. Thank you for asking it earlier. Soul Wound saying, what if the guys who sold the debt to Joe gave him the judgment document? It's your job as the debt collector to check and verify. It doesn't matter if a guy hands you a pile of paper. You have to make sure those are valid judgments. And as J-Rock, who does this for a living, says, a good compliance officers are key in these types of things. When you're dealing with like consumer protection, you're dealing with things where there's a lot of government oversight and regulation. You have compliance people, somebody there to make sure that, hey, is this a valid debt? Can I look this up online? I can't find it. Can I call this court? Hey, civil court in New York County. Hey, is this a legitimate thing? No. Oh, okay. Well, shit. We shouldn't buy it. Or, oh, is it cool? Yes. All right, cool. Put this in the we can go after it pile. You check and verify. So it's just doing due diligence, but it doesn't make any sense. Deadman 666. I see Deadman 666 is a new member. Well, thank you. Thank you for being here. I appreciate your support and welcome. Welcome. You'll enjoy it. We do try to do a bunch of members only stuff throughout the week, and we did one on Wednesday. It was a lot of fun. J-Rock says there ain't no insurance for this. Yeah, that becomes an issue because generally it's so dangerous of an area. And then you run into the issue of they won't insure for intentional acts anyway. Yeah, a law where you can break it even unintentionally is not something you want to insure someone on. Joe should have called Barnes, yes. Then Eganoy says potentially late, yes. Yes, I'm sorry. But thank you for being here. It's a name I don't recognize, so thank you for stopping by. Parallax has been a member for 23 months. And thank you for that. I appreciate that. Saying, did you choose Shabbos specifically for the laughs? No. I just had a chance that I got read up on it, and I didn't know how long these documents were going to be. But it's not. It's in a lot of Fair Debt Collection Practice Act cases, they're not super in depth. This one has a shitload of entries on it, but the actual relevant documents are like, boop, very short to get through and very easy to digest. I thought it was going to take me a lot longer, but no, I was able to blow through it pretty quick. Ag is saying, thank fuck, a law that actually works. Well, it does to an extent. Truck Golfer says, no crime committed. Well, so far, but remember, it's one of those deals where people out there fucked around and they fucked it up for everybody else. And Trot says, if you don't pay your bills, fuck you, honor what you put yourself into. And I don't disagree with you, but the way that they would go about collecting debt was really fucked up. Should they be allowed to threaten you with fake legal process? I don't think you should be allowed to do that. Should you be allowed to threaten people, period? No. Should they be, I think there's ways they could do it. And, it was the asshole debt collectors who fucked it up for everyone else. No Mandate says Ashkenazis do not lose lawsuits for the record. Yes, thank you. No mandates. 2 cookies for a write-out says usuries against the Torah. Yes, I understand. But yes, J-Rack, as you said this earlier, I'm wondering why they didn't sue in Southern District of Florida. Like I said, there's a lot of what the fuck in this case. There's a lot of what the fuck that doesn't add up. Because traditionally under the Collection Act, you have the right to sue in where you live. Benjamin Lewis says, Joe is innocent. Grounds. Did do nothing. Not proven. Yes. Michael Martin says, the best advice I ever got was, if you have to eat crow, eat it while it's young and tender. Yes, that is true. Eat it while it's still warm. The longer you wait, the worse it gets. And then Loknav saying, for 10, what do you call them, remaining currency? Remaining currency is the Romanian leu. I forgot. Yes. For 10 Romanian leu. Not for 10 Romanian guys named Lou, but just 10 Romanian Lou. Says, thank you. You're welcome. And then Tyler over at the Libertarian Podcast Review. He just got done doing a pretty good show. I watched a little bit. I watched the first part of it. It says, have a good weekend. You too, man. You too. We're going to link up soon. It'll be a lot of fun. I Am Shout became a member. Well, thank you. Thank you. Thank you for being here. Or is it I Am Shout? Or is it just I Am Shout? Not sure which way, but either way, thank you for being here. I appreciate the support. All right, guys, we're going to keep going. We're going to keep going here. Matt says most debt buyers can't verify because they usually don't get the original paperwork. Yeah, but that's where you have to spend the money. You have to spend the money going around and trying to figure out where this debt came from. And if you can't trace the debt back, sometimes it's not worth buying it. Because remember, your ass is grass. But also, there are a lot of debt collectors who still break the law, and they just bank on the fact that you aren't going to report them to the Federal Trade Commission, which that happens a ton. That happens a ton. Brad says, could the seller be liable for fraud? I mean, Joe would have to turn around and say those guys were fraudulent, but he has never claimed that. But even then, remember, it's your duty as the debt collector to verify the debt before you go in. You have to make sure it's valid. And then if he had done all that and found out, oh, these guys fucking lied to me, he could turn around and sue them for his money back. But it looks like he didn't go back and check it before he jumped off. Yeah, so I don't buy the idea that it was a bullshit debt. Something just, yeah. So, Philip Martin says if they did find it, would be the threat of contempt, and jail will be a problem. Oh, hold on here. I think you're trying to say, so if they did find it, would the threat of contempt and jail be a problem? You mean if there was a debt, could they still threaten you with jail? No, they can't put that there. Remember, getting civil contempt for jail is like fucking almost impossible. That's like winning the lottery. Kind of lucky. Robin says there's liability for the attorneys. Yeah, at times there can be. And usually, I mean, if they went ahead with it, yeah, there could be liability for the attorneys. And if it's let's say you own a debt collection company, but you hire an attorney to work, like you hire a law firm to do the work for you, and they fuck up, well, yeah, you could turn around and sue them. But usually you have your own attorney if you're in a debt collection situation. You either are an attorney collecting debt or you work for a company and you are an attorney doing work on their behalf. Sylvia is saying, sent by Nick. Well, guys, thank you. Yeah, there is personal liability of attorneys and officers under the FDCPA. Yeah. Yeah, if you're the attorney working for that company, yeah, there's still liability, but it's not the same. Diamonds Ahead is saying, is Joe facing jail time as of the second? No, there's none of that. The Fair Debt Collection Practice Act is all about civil penalties, and it's about money. That's why I said he's facing a $117,000 judgment. But that's why I'm pointing out, if it's proven that this is all fake and all the documents are bullshit, then yeah, you're looking at forgery. You're looking at a bunch of crimes. But you're going to have to prove that and prove it to a level that you could sustain a conviction. But as of right now, none of that's there. Amon Rezu saying, can Joe can be disbarred, right? No, not just for this alone. No. Attorneys fuck up all the time. Fuck cases up, fuck things up. No, that doesn't get you disbarred. Yes, the secondary issue, remember that if it were true that he forged these documents, and if all those things happen, then yes, that could easily get there, because now you've got a major character and fitness issue, a trustworthiness issue, a credibility issue. Yes, that could easily lead to it. But this case itself, this judgment, that won't be that necessarily wouldn't make a blip on the state bar's radar, but it's the situation behind it. Yeah, that might get referred to the state bar by people involved, because they'll be like, oh shit. So like I said, as of right now, no, none of that's going to happen. But if it turns out this was all bullshit and they can prove it, yeah, that's a separate matter. This will not automatically lead to anything. Stacy says attorneys fuck up all the time. They do. I fuck up. Any attorney out there is going to fuck up. I bet Ron Coleman's fucked up before. Probably not too many times. Ron seems like a pretty good attorney. Ron's far better than I'll ever be. But I'm sure Ron's fucked up. Tyler out there, Libertarian Podcast Review, he's fucked up before. Nobody's perfect at this. Nobody hits, nobody bats 1,000. Nobody ever bats 1,000. Ted Williams, at his best, was like batting what, 405 for that streak when he was like just drilling it. Remember, that's only like a 40% hit rate. So J-Rock says, not me. Yes, you're the best, J-Rock. You're our daddy. Sula says it was 406. Okay, well. All right. Yes, only Legal Eagle never fucks up. And lead attorney. Well, here's you know what though? I guys, if you're not, and real quick, this is a side tangent. If you guys haven't checked in on lead attorney, show him some love. He's going through a lot right now. I know he disclosed it. He's apparently is suffering. He's got cancer, and apparently it's terminal in the sense that it's like a 5-year or so longevity of the prognosis. So it's not like he's only got like 90 days to live or something. But he's on there, and I mean, listen to his story talking about it. It's actually pretty inspiring. He comes through that pretty upbeat. I mean, he's had a lot of time to dwell and think about it. But if you guys, get the chance, you ever see him on, pop on, say hi, man. Show him some support. I know he'd appreciate it. And LPR says that's why we never let our liability insurance lapse. Very true. Very, very true. Yeah, God be with Lead. Yes. Yep. I wish him truly nothing but the best. I know he seems to be at peace with things right now, but I'm hoping, it's 5 years, 10 years, 20 years. Hopefully he can come back to us in a year from now and saying, guys, it's all gone. So J-Rock says, my only failure is not winning 100 to 110%, being capped at 100. Jesus. Oh, my God. So. Anyway, guys, I don't mean to bring you down with all of that, but the lead attorney. But like I said, if you guys ever happen to be on and he's on, show him some love. I'm not telling you, like, if you want to give him a super chat, cool. But I mean, like, just show him some support. Go on there, give him a like, give him a hey, man, what's up? Listen to him and be like, you rock or whatever. Just, dude, show him some support out there. Now, what do we do with all of this stuff? Like, what happened? Now, getting back to Joe. So, what happened with Joe? Well, both parties ended up filing for summary judgment. And guys, if you remember, summary judgment is where you come in and you say, Your Honor, we feel there's no disagreement on the facts. It's just a matter of applying the law. We're actually demanding you make a judgment, a summary judgment. It's like a summary execution right here on the spot. Boom. And a summary judgment happens and the judge says, okay, fine. And sometimes the judge goes, the winner is the red corner. Sometimes he goes, the winner is the blue corner. Sometimes he says, both of you win and both of you lose. Or he says, you win on 9 out of the 10 things. You win on one of them. There's a million different ways it can go. So what happened here? Well, there was an opinion about the summary judgments that were filed. And this comes out in 2022. Remember, this is back in 2021. They filed for summary judgment. I'm not going to read the arguments in it because the complaint is not contested in a lot of the issues here, ultimately. So, there are before the court a defendant's motion for summary judgment seeking to dismiss all claims, and plaintiff's cross motion for summary judgment seeking to impose liability on all claims. So Joe's saying, nope, none of it's good. The plaintiff's saying, wait, all of it's good. And every once in a while, you'll have parties filing cross claims saying, all my shit's good, their shit's bad. And you have the defendant and the plaintiff both saying that. So as you can see, there were replies and cross oppositions. There was a cross motion reply. There was a lot of motion practice done there. So they say for the reasons below, the defendant's motion for summary judgment is granted in part and denied in part. And the plaintiff's motion is granted in part and denied in part. So like I said, Court says you win on some things and you win on some things, but neither of you wins all the way. So the court dismissed the New York general business law claim as well as the plaintiff's claims, some of the claims under the Fair Debt Collection Practice Act. Okay, so the 1692 E10 and F1 claims, and granted summary judgment in favor of the E5 and E13 claims. Well, now we need to say, well, wait, what the hell does all that actually mean? Well, we have to go and look at it. So, because, well, do you know what that means? I mean, I don't think you do. So that's why we're going to take a look at it. Oh. So this is, and we're going to cheat here and just get down to, wait, when did this? So we're going to get to what's going on here. Anyway, we're going to keep going here because it's going to explain what happens. So the background, the facts are taken below from the complaint. And Rule 56 is where you get to summary judgment. So, guys, we talk about, summary judgment under Rule 12b6, and it's kind of like, there's a failure to state a claim upon which relief can be granted, and that's considered summary judgment at times. You hear us talk about it, but real summary judgment is Rule 56, and that's where the court can make findings and go forward on stuff. Okay, so anywhere there's not a dispute, the affidavits, declarations, and exhibits will be admitted. All rational inferences are drawn in favor of the non-moving party. So where Joe has made motions for summary judgment, Levy gets a benefit of the inferences, and where Levy has made motions for summary judgment, Joe gets the inferences drawn in his favor. Now, notice they point out a bunch of things here. He is the solo practitioner at the law offices of Joe Neerman. Joe Neerman was a co-founder and employee of Return of Judgment. In 2015, Joe became the 100% owner of Return of Judgment. Now, I know in the depositions there's some monkeying around with this and was I really in that? Okay, well, yeah, I'm not going to get into it, guys. There's a lot there if you want to read the transcripts. The depositions are very interesting, the parts I've seen. Through Return of Judgment, Joe practiced judgment execution. Many of the judgments brought to ROJ were ultimately assigned to Return of Judgment. So when they talk about the letter dated September 10th or December 10th and postmarked the 13th, notice that's all true. That everybody agrees those are true things. The judgment was for $13,000 awarded in the New York Civil Court case, Morrison v. Levy. Subpoena commanded the plaintiff to appear on the 26th at 10 a.m. All that stuff. We've got all of that. They go through all the things there, saying that they said we didn't recognize the underlying action, and Joe said, "I'll send you the underlying file." And when they tried to follow up later, Joe didn't respond. And then after checking, plaintiff's counsel conducted an independent search with the Supreme Court clerk's office, and they couldn't find anything. And at some point, Vera Porat, Joe's office manager, submitted a sworn declaration stating she was responsible for having prepared the letter, and it had never been reviewed by Joe. She explains they were sent out during a busy period when she was training staff for WAC Enterprises, an entity that agreed to take over ROJ's assets. Joe avers that even though WAC has now taken over the assets, Return of Judgment remains under his name. So Joe's office lady is trying to say, look, it was all my fault. That's not good enough, because when you're an attorney, your office staff, if they send shit out with your name on it, if it goes out the door with your name on it, it's yours. If it goes out the door with your name on it, guess what, chat? It's yours. My sword just fell over. Oh boy. Oh, well. There's no hiding behind that. There's no hiding behind that. You're not allowed to. Can't go, oh, it wasn't my fault. It was my, dumbass secretary. Sorry. Your name's on it. You hired them. You are responsible for your people. We don't let attorneys escape on it that easy. Now, there are times where she may do something completely off the fucking reservation. Maybe that you escape liability. But this is not a situation where that's going to happen. So the procedural background, the plaintiff submitted a request for an entry of default against Joe after they failed to timely respond to the complaint, and the court issued an order to show cause for default judgment in March of 2018. So what that means is they send out something to Joe saying, hey, you guys need to show up and explain why the fuck we shouldn't do a default judgment against you. So the court held a show cause hearing at which the court ordered defense counsel to file appropriate appearances for each defendant and required a motion seeking leave to file an answer by May 4th. So, and this is not uncommon. Just because you miss a norm, and this is where, once again, as an attorney, don't panic. If you go to court and say, look, here's what happened. We fucked up. Can we have time to respond? Most courts are going to say, cool, you know what? Take your shot. So they had a chance to file an answer. So the show cause hearing was adjourned to the May 31st. Following the show cause and under the plaintiff's motion, the court found good cause to set aside the entries of default against the defendants. So the court said, you know what? We're going to set it aside, litigate the case. We're not giving you the default. It's not that easy. Actually do the fucking work on it. Okay. Yes, whack Lom. Oh, yes. And we go along. On November 6, 2020, defendants were granted leave to file a summary judgment motion. Plaintiffs sought leave to file a summary judgment motion. And the parties completed their briefing on April 30th, 2021. And guys, this is not abnormal at all. Remember, this is the middle of COVID, but motion practice where you're going back and forth and everybody's taking shots, not uncommon at all. So the standard review is Rule 56. If the movement shows there's no genuine dispute as to any material fact, then the movement is entitled to judgment as a matter of law. Because, if we agree on all the facts, well, the court can make a decision. The moving party bears the initial burden of pointing to evidence in the record, which it believes demonstrates there is the absence of a genuine issue material fact. And if you guys have ever noticed a lot of these cases, you'll see things like Celotex v. Ketrit. These are cases that are like the foundations for, this is like Terry v. Ohio for civil procedure, or Matt v. Ohio, or, Bertine versus Colorado. Oh shit, most people don't know that one. That's, Bertine versus Colorado, regarding, inventory searches, or, insert whatever other case of Michigan v. Long, or Quarles v. New York, or Enos versus Rhode Island, or Dix v. New Jersey. There's all kinds of cases out there like that. Or Garrity versus New Jersey. If you're a cop, you know what that is. There are so many different cases like this in civil procedure in the civil world as well. So the moving party may support there's no genuine dispute of a particular fact by showing the adverse party cannot produce admissible evidence to support the fact. And the civil procedure rules at the federal level are pretty much mirrored at the state level as well. So if you fulfill your preliminary burden, the burden shifts to the non-moving party to raise the existence of a genuine issue material fact. If there is a genuine issue material fact, there cannot be summary judgment and the case has to proceed. So why am I not gooning over the right alignment? Well, because it's a judge, it's a court judgment, like a court entry. Like I expect the Southern District of New York to have their shit together. That's why I'm not worried. It's the Southern fucking District of New York. This is like this is Monday night in the NFL, the Southern District of New York. You're playing under the lights here, kids. I expect them to have their shit together. Ralph says, my father's ring says otherwise. Solon says the SDNY, okay, the U.S. Attorney's Office for the Southern District of New York is a joke, but itself is not the court's not bad. It's the big time. It's where everything happens, man. It's the center of commerce, the center of everything. All right, so we need to move on. So we're talking about all the issues here, but the discussion, actually, we can get to what's actually looking here. And guys, look, we can talk about the rest of this. We can talk about Matsushita Electrical Industries Company versus Zenith Radio Corporation. That's another one of those big cases. There's a bunch more up that are in here. If you really want to talk about them, we can. Anderson versus Liberty Lobby. That's another one that's kind of a big one. That's an oldie but a goodie. There's all kinds of shit out there. They talk about second district cases because the Second Circuit. Remember, New York is in the Second Circuit. So that's why you'll see them. You guys talking about pagers. So anyways, the defendants move for summary judgment to dismiss the FDCPA claims and the general business law claims. Arguing both claims fail on the merits. So for the FDCPA claim, the plaintiff seeks statutory damages of up to $1,000, actual damages based on emotional harm and attorney's cost. And the emotional harm is this guy's sitting there saying like, holy shit, I was getting threatened with jail time. And this guy's like, you've got like 10 days to show up to New York City and come in on, the day after Christmas when everything's closed. And you're coming here to, hello, fellow tribe member. We're going to sort this out. And the guy's like, oh my God, I don't know what to do. And he hired an attorney. I'm panicking. So that's where they go with this. That's the argument they're making. Mark is saying Joe may have rubbed the New York courts the wrong way with the Young Gag Trump case. No. This was a long time coming. When we've got a couple more documents to get to. This is kind of like a laser guided bomb had been dropped at 30,000 feet. Once you drop it, there's only one way that goes. So it's not like there was a way the bomb would have magically stopped at any point. It's just going shh. So this was going to happen when we get to the end. This was an inevitability. Very much like the Merovingian. It's like, what is inevitable? So there was no way around this. Anna Wall says, I'm flexing my civil chops. My civil chops are not very good. I'm only good in my civil chops are not good. My research is good. And the fact I'm willing to, kind of dogfight with things is about the only thing I have good civil wise. My civil law tank is not very deep. Anubis says, or a tow wire guided missile. Well, with the tow, you could actually like steer it off target. My point is, like, once you drop the bomb, it's there's only one way it's going, and it's going to the ground. I'm doing well so far. Well, so far. Anyway, we're going to keep going. So the plaintiff seeks an injunction against the defendant sending out subpoenas of the type received by the plaintiff to any consumer via regular mail, and an injunction against sending out inaccurate subpoenas, as well as 3 times the actual damages up to $1,000. So that's where we get a lot of this. It's a couple $1,000, like $3,000 plus attorney's fees at that point. And remember, guys, with the attorney's fees, as long as the case is going, the meter is running. For all the reasons below, the court finds the defendants are liable under sections E5 and E13, but dismiss the other 2. And they talk about the FDCPA eliminating abusive debt collection practices by debt collectors, and to ensure they refrain from abusive debt collection practices that are not competitively disadvantaged, promote consistent state action to protect consumers against abuse. And it's funny because they cite a case here, and we're going to get to it. To achieve this, among other things, certain notice and timing requirements on efforts by the debt collectors. And Goldstein versus Ingram Usick. I'm sure those are just good, healthy Italian names, like Bertololi or Bertolotti. Oh. Anyways, they move on to section 1692K of the Act provides that any debt collector who fails to comply with the provisions is liable to such person. A single violation is sufficient to establish liability. And the court considers the frequency or number of violations in calculating damages. The court may not, however, regardless of the number of violations, impose more than $1,000 on the penalty provided for such actions as these in the absence of actual damages. So your maximum statutory damage is $1,000. So if you notice, when J-Rock said at the beginning, you settle right away. You write a $1,000 check plus something for attorney's fees. Fuck off. You're done. That's pretty cheap. That's if you were doing this as a major business where you're making millions of dollars a year, write a $1,000 check. Part of that's the cost of doing business once in a while. Write it and get done. And J-Rock says there's a whole plaintiff's industry dedicated to suing under the Fair Debt Collection Practices Act. Yep. Just like under the Americans with Disabilities Act. Except in this one, you're like trying to scratch out a little bit of money and you're hoping you'll sue a debt company and they'll, like, if they kind of fucked up, they'll cut a check and you get your piece and your client gets a piece and then you get attorney's fees and a little bit of the action and then you go your way. It's about volume at that point. So usually around 4K. Okay, the same thing though. Oh, all right. Well, there you go. Yeah. If your company's worth a couple $1 million in revenue, a couple lawsuits at 4Gs a piece, fuck. It's cost of business. Write it out, scratch those checks, and write it off as a loss. Demon's Wrath says base chat would build a total Nippa death tower. And Iman Reza says this build site isn't organized enough for that. Well, hey, there's a union. You guys could get some union workers, I guess. Oh no. Yeah, well. All right. To state a claim under the Fair Debt Collection Practices Act, the plaintiff must demonstrate the plaintiff is the person who is the object of the efforts to collect the debt. The defendant as a debt collector is defined in the statute, and there's very few people that would not count anymore after amendments. And the defendant engaged in an act or admission in violation of the act. So they argue that they are not debt collectors. Okay, well, Joe says we're not debt collectors under the act. And they claim that Neerman and Loan were not involved in creating or distributing the unlawful communications of the plaintiff, and the letter and subpoena did not violate the FDCPA, and that the questions of fact surrounding defendants asserted bona fide error defense. And remember, guys, I told you, that is the defense you can assert. It's a bona fide error. Look, it's a legitimate error. We fucked up. Remember, it's a very, very small area you can thread through. You got to thread the needle on it. So the court's going to determine what happens here. And this part, oh, come on. Do not do this. No widows or orphans. Fuck. It's sloppy. It looks like shit. So the debt collector is any person who uses any instrumentality of interstate commerce or the mails in any business in the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly, debts owed or due asserted to be owed or due another. Okay, so you have to determine that. They say, thus a company can fall under the scope of the definition if its principal purpose is debt collection, or regularly attempts to collect debts directly or indirectly. Well, there you go. So, return of judgment argues it's not a debt collector. Well, citing to Henson v. Santander, Joe avers because it is merely it collects debts that it purchases and does not collect debts on behalf of other entities. It therefore cannot be considered a debt collector. So that doesn't work. They point out the Supreme Court in that case acknowledged an alternative definition of debt collector is one that encompasses those engaged in any business the principal purpose of is the collection of debts. So, yeah, based on the defendant's own submissions, it's clear ROJ's principal business was debt collection, and therefore it must necessarily qualify as a debt collector. And then they talk about, because Joe submitted a declaration, and declarations where you make statements, and its method of operation was to have judgments assigned to ROJ and create a contractual relationship with the original or prior judgment creditor. Each judgment will be legally signed to ROJ and belong to ROJ alone at any time that ROJ will be taking steps to execute the judgment. And they point out ROJ was in the business of judgment execution on behalf of third parties. And then Joe himself claimed himself and his law office were not debt collectors. Well, there's some issues. Joe argued that while Joe's signature appeared on the letter, and though the letter was sent on his firm's letterhead, Neerman or the office never sent any collection letters or delivered litigation papers of any kind to anybody. Look, and I know you guys are saying, well, this is a bullshit argument. You run with what you got, guys. You work with what you have here. There's no other way around this. There's no other way around it. So, and they point out that these were all sent for the sole benefit of ROJ. They point out, though, that they are debt collectors. Joe concedes in his declaration that operating under the name LOJN would serve as counsel for ROJ and only ROJ. Well, yeah. In light of the concession, they are debt collectors given their sole services to ROJ. So they are debt collectors. Now, they do point out there is that attorneys can send a debt collection letter without being involved as an attorney within the collection process, so long as the letter includes disclaimers that should make it clear, even to the least sophisticated consumer, meaning a moron, that the firm or attorney sending the letter is not at the time of the transmission acting as an attorney. That's not, I would never want to be in that position. That sounds really fucking hard to do. And basically you have to prove like this guy's too retarded, he wouldn't figure it out. That's way too much gray area. Way too much fucking gray area. They point out there's no disclaimer on the letter or subpoena sufficient to provide charity to the least sophisticated consumer that Joe nor his office were not acting as attorneys for ROJ. Whether the defendants, Neerman and his office, Joe and his office, are liable for the unlawful communications. They argue that even if we're debt collectors, we're not responsible for the letter and subpoena sent to plaintiff, nor did they review the items before they were sent. Instead, they claim the office manager, once again, she did it on her own and fucked up. If they didn't directly send out the letter, they authorized ROJ employees to use their letterhead and signature without review. Remember what I said, chat? Your office staff, as an attorney, if they do shit on your behalf and are using your name, you're fucked. Using your letterhead, that's not good either. You know, that's why you have to be careful of the people you hire. You have to supervise them. And they say, therefore, Joe and his office can be held liable for the communications. And notice they cite a Sixth Circuit case. And they say, whether the letter and subpoena violated the Fair Debt Collection Practices Act. Now, this is the big thing. So what are the issues here? Plaintiff argues the subpoena was unenforceable because New York law makes service a subpoena upon an out-of-state judgment debtor void. And they point out, New York courts pointing out, subpoena served upon a defendant outside the state of New York is void. The Israel Discount Bank. I saw that before. That's a hilarious thing. That is very hilarious. The Israel Discount Bank. Oh. It was improperly served because it was sent via regular mail rather than the same manner as a summons under New York rules. It required a deposition date that fell on December 26th, a federal holiday, in violation of civil rules. And it was not timely under New York civil rules because plaintiff had less than 10 days notice of the date and lacked the statutorily required language set forth in other New York court rules. The defendants concede the subpoena was unenforceable, particularly because service was improper and because the deposition date was defective, but argue that that is nonetheless not a FDCPA violation. Well, there you go. I mean, he's admitting, yeah, I fucked up, but yeah. Oh. Yeah, there you go. There you go. Well, you guys are sticking around, so this must be interesting enough. So the court will discuss the E and F claims in turn. Section 1692E. E as in echo, echo, echo. And we're going to get to these real quick here. Because this is important to look at. False or misleading representations. So you may not use any false, deceptive, misleading representation to collect debt. So you can't do a false representation that you are vouched for, bonded, or affiliated with the United States government or any state government, including the use of any badges, uniforms, or facsimiles. And I know, Trot Golfer, you're out there. This is shit people would do before the law came into effect. They would act as though they had authority, or I'm licensed, or I'm bonded, or the government backs me up. And sure, people need to pay their debts, but I don't want people running around fucking pretending to be the government like that. You know, because you're committing fraud to collect a debt. And this shit is an example. Like, they wrote this all down because people were doing this. You can't lie about the amount or legal status of the debt. You can't, false representations that you're an attorney or the communication is from an attorney. People used to do that all the time too. They'd lie about being an attorney. That happened all the time. That any non-payment would result in arrest or imprisonment. Or that, that you're not allowed to do that. Or that there would be garnishment, seizure, or attachment, sale of any property unless such action is lawful and the debt collector intends to take such action. So you can do that. You can say, I'm going to garnish your wages. I'll attach to your properties and put liens on your property. I'll seek sale of your property. I'll seek anything I could do. I can't threaten you with arrest or imprisonment. But I have to intend to take these legal actions. If I don't intend to ever do it, that's illegal. Threat to take action that cannot legally be taken or is not intended to be taken. The false representation that the sale or referral or transfer of interest in a debt shall cause the consumer to lose any defense of the debt. So they're saying, if you don't get a hold of me before I sell it, well, you're on your own. You're at the mercy of the people out there. That the representation or implication you committed a crime or other conduct to scare or disgrace someone. Communicating or threatening to communicate to any person credit information which should be known to be false, including the failure to communicate that a disputed debt is disputed. Any documents where you're claiming that they're represented or supported by a court, the United States, a state government, or a false impression as its authorization. That would happen all the time too. The reasons why these are so specific is because this is shit that would happen all the time. People, like, debt collection was a fucking scummy fucking business before the feds got involved. The use of false representation or deceptive means to collect or attempt to collect debt concerning a consumer. I mean, and it goes on and on and on, guys, here. It goes on, but these are the big ones here, up to 10. And we're going to get to where this goes from here. Oh, shit. You guys did did you guys really just do this? Pseudo Snark says, I'm late, but I pressed the like button. Blame Tyler Yankee. Well, thank you. Thank you for being a member for 9 months. Nick Starro's been a member for 2 months. He says 2 months only feels longer. Mystery Sniper says for 10 months, do a segment on Lake County to make it make sense. I'll talk to you more about that, like I said. But no, the Lorain County prosecutor facing felony charges for paying off his girlfriend. That's actually going to be very interesting if he gets indicted. Oh. You guys just, holy shit, guys. You guys are going crazy. Well, we'll get to those in a minute. We got to keep going here. So, anyway, 1692 prevents debt collectors from making the false, deceptive, misleading representations. It's a strict liability, so you don't have to prove that it was intentional. And, look, for LSV Solomon and Solomon, once again. Anyways, a consumer does not need to show intentional conduct on the part of a debt collector. So, they point out there's 2 things here. The act is liberally construed to effectuate its purpose of consumer protection, and collection notices are analyzed from the perspective of the least sophisticated consumer. So even if you're smarter than the average bear, you're looking at not even the average bear, but the dumbest fucking bear. Least sophisticated. That's their way of saying blithering fucking idiots. Chat. Blithering fucking idiots. So the least sophisticated consumer test is an objective one that pays no attention to the circumstances of the particular debtor. This doesn't mean wholly unsophisticated. They presume to possess a rudimentary amount of information about the world and a willingness to read a collection notice with some care. So courts focus on whether the false statement will frustrate a consumer's ability to intelligently choose his or her response. Technical falsehoods mislead no one are immaterial and consequently not actionable. The court points out it's unclear whether there is indeed a valid Morrison judgment. The defendants insist that there is one, and in their submission attach a transcript of judgment signed by a New York Civil Housing Court judge and a sworn acknowledgement of assignment of judgment pertaining to the underlying case. The plaintiff states that he is not aware of such judgment. His counsel called the clerks, and they can't find it, who couldn't identify the case number. In his answer to the defendant's counterclaim, however, plaintiff admits he received a copy of a document that purports to be the Morrison judgment against plaintiff, but lacks knowledge or information sufficient to form belief as to whether the judgment was properly filed or docketed by the clerk of the court and was or remains valid and enforceable. Now, here's the thing. This part right here, that's where I told you guys, this gets weird. This gets really fucking weird. What happened? Because now the plaintiff's admitting, yeah, I think I got something about something like this back in 2010, but I don't remember fuck all about it. Well, now that leads us to, remember how a guy said, like, if this was forged, we got a problem. But I'm like, going out of your way to forge a document doesn't make any sense. So it sounds like this guy got some documents. So did this get lost in the court system? It very well could have. That's just really fucking crazy that this case doesn't fucking exist anywhere. I'm not saying it can't happen, but it could happen. Is it going to happen out in Hee-Hawville, Ohio? Not very likely. In the bowels of New York City, could I see that happening? Possibly, but we don't know what happened. So we really don't know. We really don't know what happened. We just don't know. It doesn't make any... Once again, guys, like I said, this doesn't make any sense. So like I said, you guys are saying like, oh, that was fake. And like, it could possibly, sure, but there's not enough evidence for me to tell it's fake. And I looked at this earlier. This statement here gives Joe enough to say this isn't fake. And I would agree at this point. And J-Rock, you're saying at this point, it's not the validity of the debt, but the collection efforts. I don't disagree with you. But here's the thing. That validity of the debt, though, is a secondary, bigger liability for Joe. Because, people are saying, well, it was forged. But if it was forged, how do these people get a copy of it? Or how do they know something happened? Well, that lends the idea that it's not forged. Therefore, this idea that Joe could be held liable for criminal action, that pretty much goes away. Because somebody else is saying, like, well, yeah, I got documents about something like this. But fuck it. It's been, it's fucking, now it's fucking 12, 13 years ago. I don't remember shit about that. David says your face doesn't make any sense. Your mom doesn't make any sense. So it's weird. It's very, very weird. It's not funny. It's just weird. There's also the idea, guys, getting here to this last part, whether it's enforceable anymore. If you have judgment against a party, you have to renew and revalidate that judgment every couple of years. You have to re-record it. You have to do things to keep the judgment alive. So the reason is you can't collect on a debt like 35 years later and say, you owe me, unless you've been out there collecting on it and keeping it valid. Same thing with liens. You have to re-record liens. You have to re-record them and keep them fresh. Well, so if you have a lien and it's 25 years later and you didn't do anything about it, you can't go back and collect now. They also point out the plaintiff has not made any affirmative statement in his motion papers confirming or denying the existence of a valid judgment. And that's a big thing because they're admitting, like, we don't fucking know. We don't fucking know. Now, the court points out, assuming that even if it's valid, the court finds the letter violated 1692E, particularly as defendants conceded the subpoena was unenforceable. Generally speaking, as plaintiff correctly argues, a least sophisticated consumer receiving the notice, which states final notice across all the pages, would have understood that he or she would have to comply with his appearance and document production requests, or else face court-imposed punishment. The subpoena would have also influenced a least sophisticated consumer regarding their ability to respond or dispute the collection. Yeah, there's no more time. It's like, well, they didn't have a chance before, and now they would assume, oh God, I'm fucked. And they point out under E5, the defendants are liable if they use a threat to take any action that cannot legally be taken or is not intended to be taken. A false threat exists where the least sophisticated consumer would interpret the debt collector's language to mean that legal action was authorized, likely, and imminent. And here it's clear. It commanded the plaintiff to appear before a deposition on short notice and produce documents for examination. It indicated the failure to comply was punishable as contempt of court. Moreover, as plaintiff's counsel called Neerman to ask about the action, there's no indication in the record that Neerman took any action to confirm that the subpoena was not enforceable and that it could be disregarded. And that's something Joe could have done at the time. And they called him and said, like, hey, man, what are we doing with this? And Joe could have been like, hey, you know what? Actually, you know what? Fuck it. Don't worry about it. That's all fucked up. We'll fix it. We're going to send out a different notice. Don't worry. And if you're counsel of record, we'll serve the subpoena on you. We'll get the subpoena to you. Yes, J-Rock, it's the final notice. It's the final notice. Oy vey vey. Oy vey vey vey. Oh. And instead he indicated he would follow up with the court file. Therefore, the court finds a violation of E5. And this is where if Joe would have just said, you know what, hey, we fucked up, there might not have even been an FDCPA action. There might have just been like a $1,000 payout. How much is your attorney's fees on that? Or hope they don't do it. They might not have done anything at all. This guy might have just been out like $400 or $500 paying the attorneys. He might not have filed anything. It's just like, this is where a little issue just grew and grew and grew and grew and grew. Whereas if you had fixed it right at the start, like I said, guys, this is something, especially you see attorneys do this where they fuck it up, and attorneys who get in really bad trouble with the courts and the bar associations, they let a little problem, which, okay, might be embarrassing, it might be painful as a little problem. It's the size of a pea. And by the time it's out of control, it's the size of a boulder. Little problems require little work. And it's a little pain. Big problems are a lot of work and a lot of pain. So. Runkle says, I'm glad I've not gotten any legal dirt so far. You are Canadian, so don't worry. You're probably too polite to have done anything wrong, Runkle. Yes, I'm sure the scandalous thing about Runkle is one time he didn't say sorry to somebody. He bumped into him and didn't go, sorry. He just kept walking. Guys, Runkle the Bailey is a very good channel if you guys want to watch some good stuff out there. Very humorous, very cool guy. He's actually working as a Canadian firearms attorney, getting like a machine gun license, which is pretty cool. Pretty freaking based. So we're going to keep going here, guys. The court also finds a subpoena violates 92E13, which prohibits falsely representing that documents are legal process. The subpoena is captioned in the formatting typically used to file documents in New York City civil court. Therefore, there would be the impression legal process is upon him, but it's not. And however, with respect to E10, which prohibits making of false representations and deceptive means to collect any debt, the court finds that the plaintiffs have not established such a violation. The plaintiff attempts to argue the issuance of the unenforceable and legally faulty subpoena itself is a false representation and deceptive mean, but points to no language that was actually false or deceptive. Now, I get what they're saying here. They're saying the underlying stuff is false, but he didn't write any false language in there. Although you might say, well, then the whole thing was bullshit, so why isn't it false language? It's he didn't include any fake things. The court finds that the numerous errors surrounding subpoena are sufficiently addressed under E5 and E13. Then there's section F1, which prohibits the debt collector from using unfair or unconscionable means to collect a debt. Unconscionable means shocking, unjust, or unfair, or affronting the sense of justice, decency, or reasonableness. So yes, it's unconscionable is very much up there when it gets to it's outrageous or it's unconscionable. They're very much in the same area here. What the hell is going on? Oh, okay. Well, you guys can all behave over there. They point out that the plaintiff specifically raises an F1 claim, which prohibits debt collectors from attempting to collect amounts not authorized by any agreement creating debt or permitted by law. The court finds this must be dismissed. The plaintiff does not meaningfully argue he establishes a violation here. They only rehash the pleading from their complaint, where he states it was violated for attempting to collect amounts not authorized by any agreement creating the debt. In any event, the court finds that it's not established because the defendants have engaged in shockingly unjust or unfair conduct, meriting liability. It has to be in bad faith, unduly prolongs legal proceedings, or requires a consumer to appear in an unnecessary hearing. Though the letter did direct the plaintiff to appear at a deposition purportedly scheduled for the day after Christmas, The plaintiff was not forced to respond or attend. This is evident by the undisputed fact the plaintiff's counsel emailed defendants on January 12th to follow up on the case, but received no response and the lack of any indication that the defense attempted to enforce the subpoena. Now, whether Joe can invoke a bona fide error defense. In order to avoid liability, they must insist the complaint turns on a clerical error, and therefore they should be able to avail themselves of the bona fide error defense. Joe concedes that the subpoena is unenforceable because there were defects in service and there was an improper date set. By their own submissions, they can't establish it. And it's a narrow carve-out for the general rule of strict liability as a defense. To avail themselves, they must prove that it wasn't intentional, that it was a result of a bona fide error, and the defendants maintain procedures reasonably adapted to avoid such an error. As J-Rock stated, compliance is critical. You don't have to be foolproof, but must be reasonable precautions. Generic procedures are not enough. The debt collector must show that it took precautions meant to eliminate this specific thing from happening. And this defense is an affirmative defense, saying you have to state, yes, I screwed up, but I have a good reason why I screwed up. Also, real quick, I don't think, Uncle, did I, yeah, sorry, Uncle, I forgot to make sure I could highlight your comments when you're in chat so I can see you better. I don't trans you to punish you. I trans you so I can see you. To survive summary judgment, the defendant must make a showing sufficient to establish the existence of a factual question as to every element of the defense. And this is interesting. The parties spend a lot of ink disputing whether the defendants maintain policies on the FDCPA. The pertinent question, however, is whether, and the court's saying, wow, well, you guys talked a lot and you didn't get the right fucking answer or answer the right question. The pertinent question, however, is whether Joe maintained procedures reasonably adapted to prevent this specific issue. Sending an out-of-state subpoena on firm letterhead signed by Joe that was defective in service and set an improper date. In her sworn statement, Joe's office manager states that mailing this out was never part of their normal process. That is not how they ever operated. And judgments of debtors residing out of New York were either farmed out to third parties and local jurisdictions, or the case was rejected by ROJ. Which, once again, guys, I said at the beginning, this seems like there is some internal Orthodox community beef. And once again, I think there's an issue about, I think everybody knew Levy didn't live in Florida and Levy must have been in New York City or something. Something was going on there. Once again, guys, this is a fucking weird case. There's some shit going on we don't know about. We don't know about it. Even the manager states the letter should never have been mailed. And she regrets the letter was ever mailed. And the letter was sent during a period where the business operations were winding down and she was training staff for the whack. And they say what's problematic is the letter was on the firm letterhead, and yet it had Joe's signature. Yet she admits that she never reviewed the file with Joe, and nor was the letter was mailed. And that ROJ's workload did not enable Joe to review every document or letter that went out the office. That is a bad thing as an attorney. You are responsible for all your shit that goes out the door. If there's too much going on, that's a problem. You have to check everything. You can rely on your paralegals and your office staff, sure. But that's a scary thing. Because if he's just signing shit and not paying attention, guess what? It's your bar license. It's not your secretary's. It's not Vera's. Joe makes a similar admission he did not review or had a system review documents and went out the door bearing his signature. It is therefore clear the defendant had no policies or procedures in place. Okay, and requiring the attorney to review of legal debt collection correspondence sent to consumers, nor any policy or procedure for error checking. The procedures must be explained along with the manner in which they were adapted to avoid the error. Only then is the mistake entitled to be treated as one made in good faith. Therefore, they failed. Moreover, in his affidavit, Joe argues on behalf of ROJ, although in this case, ROJ is represented by separate counsel, that even if ROJ did not know better, mistakenly believed the law allowed the subpoena to be served on Levy in Florida via mail, that would not rise to a violation. A mistake in the law may qualify as bona fide error. This is incorrect. And the court's saying, nope, that's not how this works. And the bona fide error defense cannot protect mistakes of law. The Supreme Court recently held that a debt collector cannot escape liability under the defense due to a mistake of law, citing United States Supreme Court precedent from 2010. Now, getting to the business law violations, this is really not as big a deal here because this is New York State consumer law. But here the records fail to show the dispute here is beyond anything unique to the parties. The defendants make a point stating the error gave rise to the complaint was a one-time error. And as we set up here, Joe and his people said, this usually never happens. We never, ever have done this. I never send shit out of state. If it's out of state, we farm it out to someone else. Okay. And the out-of-state subpoena should have never occurred. Yes. And the plaintiff failed to show the conduct that ever occurred before was likely to occur again to anyone other than the plaintiff. You know, they point out this was not a unique one-time occurrence because it involved boilerplate documents sent out by a high-volume debt collector to consumers. Well, how many times did they send out a subpoena duces tecum to an out-of-state debt collector? Once. So it doesn't help. You know, any cases that didn't fit their local parameters were farmed out to other counsel. Well, yeah. The plaintiffs also failed to show how Joe had a broader impact on consumers at large, because there's no showing of same or similar actions. And because it fails, the court dismisses the remaining parts of it. Now we get to the damages part. And it's going to be real quick, chat. How long have we been going here? 2 hours. We're making good time. We're making good time. The rest of this is going to breeze through. We're in the home stretch now, chat. The decision whether to award statutory damages and their size is in the discretion of the district court. The FDCPA directs the court to follow the considering factors, the frequency and persistence of the noncompliance, the nature of the noncompliance, and the extent to which the noncompliance was intentional, as well as any other factors that are relevant. And advice. Yes, that's yes. And a lot of names pop up there. Based on the court's finding the defendants violated two provisions of the act, the court will award statutory damages in a total amount of $500. The court finds this amount is adequate considering the violation was purportedly unintentional and arises out of one incident. And they're arguing, okay. And they're justifying it. There's other cases where they show the Second Circuit saying a $500 award is okay based on one letter. Imagine appealing a $500 fine. A $500 award of damages. Just pay the fucking $500 and be done. The remaining issue of emotional damages will be referred to the magistrate for an inquest, and she will determine that. The court also refers the attorney's fees and costs to the magistrate judge. So the court awards ultimately $500 statutory damages. We have $116,500 worth of shit to go, chat. So here we go. How do we get the rest of it here? How do we get the rest of this? Well, we're going to get to that. We're in the home stretch, chat. We are in the home stretch here. GB says, what the fuck is this for the 1,000th time? This is Joe Good Logic violating the Fair Debt Collection Practices Act. And how a simple $2,000-$3,000 settlement got out of control and now he owes $117,000. Do you understand that now? Do I have your attention? So from here, things go more and more and more. So we've already got this going. And in the meantime, Joe filed a motion to dismiss pursuant to the Federal Rules of Civil Procedure under 12b-1. And that was filed on February of this year. Well, we get to the opinion here. And this is a claim for lack of standing. That is what B1 is under Rule 12. It's 12b-1 is a lack of standing. Let's see here. So this right here was filed on 5/20/24, less than 3 days before the raid on Nick's house. It's like, yeah, says multiple storms were brewing. So this is a discussion about the motion to dismiss for claim of lack of standing. For the following reasons, it's denied. So we're going to skip the factual background, guys. We've already been through all this, blah, 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 blah. The procedural background, we get to the point, yes, the court awarded statutory damages of $500. And now the magistrate's dealing with the emotional harm in inquest proceedings. So those proceedings were held June 12th. Following the proceedings, Joe raised the issue of standing, the magistrate stayed her decision on the issue until the court made a determination regarding standing. So Joe filed his motions, the defense or the plaintiffs opposed. And let me see here. Where is... hold on here. Okay, sorry. I was trying to catch up on chat here. Clyde Cam, guys, Clyde is sleeping. Clyde, I think even 2.0 is in bed right now, so they're out there sleeping. They're being eepy. So a claim is subject to dismissal under 12b-1 if the court lacks subject matter jurisdiction to adjudicate it pursuant to a statute or constitutional authority. Now, here's the thing. You can always challenge subject matter jurisdiction because if the court never had the right to do anything, it has to stop immediately at the beginning or even at the very end. You can prove there's a lack of subject matter jurisdiction. It's done. Now, remember, that's different than personal jurisdiction because if you showed up and participated, you generally have consented to personal jurisdiction on the matter. Where a party lacks standing to bring a claim, the court lacks subject matter jurisdiction over the claim. And that's Civil Procedure 101. So Article 3 requires a plaintiff to demonstrate they have suffered a concrete and particularized injury. The injury is traceable to the challenged conduct. Injury is likely to be redressed by a favorable judicial decision. The plaintiff bears the burden of demonstrating his standing. And that comes from Lujan versus Defenders of Wildlife. That's, once again, guys, that's one of those oldie but goodie cases in the civil world. So, you have to actually suffer an actual injury. Okay? The injury can't be in law, but it has to be an injury in fact. No concrete harm, no standing. So, The plaintiff has constitutional standing. The court has to consider the issue. So therefore, the plaintiff asserts two types of allegedly concrete harms as a part of standing. His out-of-pocket loss of $3,000 to retain counsel to defend him against the initial judgment, and his emotional damages including sleep loss, anxiety, marked change of effect, disengagement from his wife and infant child, and increased assistance from his sponsor to prevent reoccurrence from previous alcoholism. Well, heck, you should just talk to Nick. Don't want to drink? Don't drink. It's easy. Why do you need a sponsor? Sounds like a pussy. In reality, I understand this can cause people to drink. The court finds that it's sufficiently demonstrated and denies the motion. So the out-of-pocket losses. Actual damages compensate a plaintiff for out-of-pocket losses, humiliation, embarrassment, mental anguish, and or emotional distress from failure to comply with the act. Only when the expense of money is inextricably bound up in a cognizable injury, such as where a plaintiff faces a risk of harm, and then spends time, money, and effort mitigating that risk, can such an expense constitute concrete harm. Well, he did. He was facing sufficient risk of harm. I don't want to go to jail. And that was all bullshit. So he spent money and time dealing with it. First, the plaintiff faced a sufficient risk of harm. Remember, the least sophisticated people. Imminent legal action from an unlawful subpoena. The subpoena is captioned in the formatting typically used to file documents. It looked legitimate. And the person sees final notice across all pages. And they didn't want to face court-imposed punishment of contempt. And it was in direct response to the subpoena, which compels compliance, that the plaintiff spent $3,000 to retain defense counsel. The retainer makes clear the plaintiff's flat fee does not cover representation of him in an affirmative claim under the Fair Debt Collection Practices Act. And that representation will have to be covered later under a different agreement. So that $3,000 alone was just to cover the beginning issue. The beginning issue alone. Rather, the plaintiff's expenditure was necessitated solely by Joe's issuance of a subpoena in contravention of the act. And they say, as a plaintiff who's been subject to an improper lawsuit can assert standing on the basis of legal fees, this is no different. This is no different. He was a subject of an improper subpoena and incurred cost to hire a lawyer to defend against the debt collection lawsuit. It's sufficient to establish a concrete harm. And therefore, they're standing. It's very easy. And they just point out Joe's arguments are brushed off. So it's denied. The plaintiff's $3,000 legal fee and the issue of attorney's fees and costs are still in effect. And this was decided by the judge presiding over everything before. If, you guys see right here, Judge Roman. Well, if we go back to the other thing, Judge Roman, December 8th, 2022, he's like, fucking, you guys take care of it. So now we move on to this one here. We're back to the standing issue. It got dismissed. Uh-oh, we're running out of road here, guys. We're running out of road. Joe's running out of road very quickly. Then we get to the report and recommendation. This is something the magistrate files for the judge to take a look at. Remember, the magistrate was told, you determine, and the judge looked at the magistrate and said, I ain't fucking touching this. You figure out the personal damages and figure all that out. So what happens from here? Well, the magistrate issued basically her recommendation report. You aren't going to call this a finding of fact and conclusions of law, but basically the magistrate's telling the judge, hey, you asked me to do the work. Here's what I think happens. Take it or leave it. Saloon says, yeah. Nick Rekieta said I could mail people false subpoenas. So here we go. Here we go, chat. So the report of recommendations to the Honorable Judge Nelson S. Roman, United States District Court Judge. Now, this is a magistrate. So this is, this talks about the action commenced in May 30th, 2017 against Joe and everything here. Going through all of this, she held an inquest hearing on June 12th, 2023. The plaintiff seeks $3,000 for reimbursement of a flat fee paid to beginning, $30,000 to $50,000 in emotional damages, as well as $193,587 in attorney's fees and costs. Woo, child. Look at that. Holy shit. Holy shit. I mean, look at that, guys. At best, I mean, think about it. The worst case scenario, if the plaintiffs got everything they wanted, almost $250,000. Almost $250,000. There you go. That's a lot of baldos. Now, here's the thing, guys. I wasn't joking. When your attorney's fees, those guys are responding to all these motions and answering emails, answering litigation, checking on the files, doing all that shit. The meter's running. And I'm not joking when that stuff happens. They might measure in tenths of an hour every 6 minutes. That adds up really fucking quick. And especially when your hourly rate is $500, $600, $700 an hour, and you've got an associate attorney in your firm, and he might be $350 an hour, and there might be a paralegal who's like $200 an hour, whatever. I don't know what the real numbers are. I'm using these just as examples so you can understand this is what's going on, guys. This is how this goes. This is how this adds up so fucking fast. Very, 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 very fast. Remember what I said, guys? That little thing, that little fire, all of a sudden it's like, whoo, it's fucking Man Gulch. You don't know what Man Gulch is, go look it up. But yeah, holy shit. Think about going back to the beginning of this. Hey, would you settle for $3,000 now? Ooh-wee. Ooh, child. Ooh-wee. The defendants opposed that request. Well, no shit. For the reasons set forth herein, I recommend the plaintiff be awarded $8,000 in actual damages, $500 statutory, and $103,000 in attorney's fees, and $5,924 in costs, for a total of $117,639.24. So we're skipping through all this. Yeah. Factual background, blah, 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 blah. Anyways, so we get to the damages inquest. At the inquest, the plaintiff and his wife of 10 years, Tessa Levy, testified in support of the emotional damages. The defense did not call any witnesses, and that's fine. They don't have to. It's not their case to prove. And they probably wouldn't have any witnesses because they don't know these people. Levy testified first. She stated when they received the letter, they had only known each other for 10 years and just had their first child together. Levy was not working at the time because she was a new mother, so the plaintiff was a sole wage earner. She said the receipt of the letter coincided with a particularly difficult period in her life because her daughter had severe colic that couldn't be relieved. So she didn't sleep at all for 3 months. Additionally, her mother was suffering from terminal cancer. So if plaintiff had to suddenly travel or was fined or imprisoned, it would have been detrimental and devastating to the family. They could not afford childcare at the time, and the plaintiff was the only one helping with their daughter. There was also emotional support to her mother and help take care for the family dog. Aw. Well, that's how that shit goes, man. Yes, to fix severe colic, give your kid cocaine. You know, the normal baby can handle this much colic, but if you give the baby cocaine, they can handle this much colic. So Levy claimed the plaintiff's behavior changed in December after he received the letter. She testified there was a quick switch where he stopped helping me with my daughter at night, and he wouldn't hold her anymore, and he wasn't sleeping himself. And maybe he was like stooping. I don't know. Who knows? Levy elaborated the plaintiff was just disconnected. He would leave the house around 4:30 in the morning. He could no longer help me walk the dog. He didn't hold their daughter anymore. He didn't help me. He was short with the baby. He was short with my dog. And Levy stated that after the plaintiff received the letter, he didn't spend any time with their terminally ill mother at all. Now, I mean, I'm not going to lie. This kind of sounds like the guy was having an affair. I mean, this letter alone just fucking drove him off the wall. I mean, really, that's just a little weird. I'm just saying. Just saying. So when counsel asked more directly how the emotional state changed, he stated he was afraid. He started working excessively and leaving the house a lot earlier. He didn't return to his normal state until early 2017, when his attorney said they'll fight this and it's all bullshit. On cross-examination, she knew that he lived in New York City in 2010, but didn't know if he lived over on 42nd Street or if he owed any money to the landlord. Plaintiff testified. He explained that he immigrated to the United States from Israel in 1990 and lived in New York City from 1990 until 2010. That's convenient. He left right before September. Well, apparently he wasn't in town when things happened, but who really knows? Painting arrows on the roof for the drones to find their way. If you know what I mean. During that time, he struggled with alcohol and drug abuse and was doing a lot of drinking and a lot of drugs while living in New York City. So it sounds like he was doing the whole rent thing, you know. Seasons of Love. 525,600 Baldos. Anyways, he acknowledged that he lived at West 42nd Street for maybe a year, but did not remember owing money to the landlord or having judgment entered against him. Plaintiff said that he received the letter in December at 16, and it was a very terrifying moment. He went, "Oy vey! Oy vey!" It was very scary. He explained that he thought if he didn't comply, he could face fines and imprisonment or was going to get arrested. The letter also confused him because it was requiring him to appear on the 26th, which is Christmas time. And I remember seeing this at the time when I read it. Apparently, it was Hanukkah as well, which it would be one thing if you are not of the Christian faith and you're doing things on, Christmas. It's the same reason why Jewish businesses are closed on Saturday, but they're open Sunday because it's not their holy day. But Joe's going to make this guy show up in the middle of Hanukkah. That takes that's some real chutzpah right there. That's some real chutzpah. The plaintiff said he did not tell anyone, his wife, about his feelings when he received the letter because there was enough pressure in the house already. The letter caused him to lose sleep. He was worried. He wasn't as available as much as he was supposed to be when it came for caring his daughter. And the letter caused him to lose focus that he had to start contacting his addiction treatment sponsor daily, even though previously he only spoke to him 3 to 4 times a week. Now, I definitely could see that causing him to possibly relapse. So, yeah, he had to contact his sponsor to make sure he's good. As to his schedule, before receiving the letter, he would leave the house around 9 and come home around 5. But the added stress caused him to wake up earlier. He began leaving between 6 and 7 a.m. and returning around 8. He also testified he stopped exercising. He began to feel better once he hired a lawyer 3 weeks after receiving the letter. However, the stress didn't abate until 6 months later when his attorneys are like, "Don't worry, we fucking got this, Holmes. Don't worry, we got this shit." When cross-examined, plaintiff clarified he may have hired counsel 2 2, 1, 2, or 3 weeks after receiving the letter, but could not remember. Okay. In addition, he acknowledged the complaint states that the attorney's first conversation with Joe was on December 27th, 14 days after the letter was marked. And that upon giving the letter to his attorney, he felt relief. Further, the plaintiff admitted that while he lived in New York, he moved out of the apartment for 2 months for addiction treatment, which is why he could not remember if he had any debt related to his tenancy. He explained when he returned to the building, all his furniture was gone and he was not allowed to enter. Once again, chat, like I said, this sounds like there was a debt. It sounds like there was a debt. It sounds like there was some shit going on. But it's weird. We can't find any fucking proof about it because the guy even admits, yeah, I came. He's like, I came back and all my furniture was gone. Who'd have thunk? I kvetched in the hallway. So once again, like I said, this thing is full of what the fuck. This thing is full of what the fuck that doesn't add up. Plaintiff acknowledged he never sought medical treatment for his anxiety caused by the letter. Yes. So what's the legal standard? So even though the courts found liability, the plaintiff bears the burden to prove damages. There has to be an evidentiary basis for the damages sought, so an inquiry must be conducted to ascertain the amount and the reasonable certainty. So the actual damages, they are included to any actual damage sustained by a person as a result of the failures to comply with it. They compensate for out-of-pocket expenses, humiliation, embarrassment, mental anguish, or emotional distress. Plaintiff argues the $3,000 spent to counsel was necessary. The letter prior to commencement of this action, as well as the $30,000 to $50,000 in emotional damages. Now, he points out that he initially got his attorneys, now known as the Schlonger Law Group, that he's required to pay $3,000 as a flat fee for representation dealing with the judgment. He was worried about his newborn daughter and wife. It triggered urges to relapse and consume alcohol. And yeah, it had emotional damage on their family. In response, they claim that he's not entitled to emotional damages. There's no objective evidence of anxiety or emotional distress. Joe posits the real reason for the distress was a letter prompted him to remember he was a deadbeat and he has to make payments, which he could not remember since the debt he was hospitalized for being an addict. Joe does not offer any opposition to the $3,000 fee paid. And the initial engagement fee makes sense because he was helping defend it. And that's not uncommon. Hey, I'll defend you up to X point. From there, you're on your own, or we'll have to negotiate further. So that's not an uncommon thing with attorneys. And the $3,000 is for representation against the judgment, helping defend against that. But with the FDCPA stuff, that was going to require a different engagement letter. And because of that, the plaintiff hired the law group to defend him against the letter. He's entitled to recover the fees. That's a cognizable monetary harm. So the emotional distress. Well, the plaintiff's entitled to those, just not in the amount requested. So here's the issue. They get to it. The letter caused him to lose sleep, disengage emotionally, and physically not care for his family. And it increases urge to relapse. I wonder if Nick's got a letter out there like that then. The court finds this all to be believable. The letter contained aggressive language about violations. It demanded voluminous records to appear on a holiday. And it attached a purported subpoena. It's conceivable that an individual receiving this letter would suffer emotional distress in some form, especially when the recipient has no recollection of the time period due to their being an addict. However, this damage is belied by the fact that the plaintiff testified he felt better after meeting with his attorney about the letter. And this meeting took place 1, 2, or 3 weeks after receiving the letter. There's also no medical corroboration of things, which you kind of need. There's no documentary evidence of the distress, and you only rely on testimony that he had to contact his sponsor more frequently. They could have got an affidavit, or they could have had that sponsor testify on Zoom. There are multiple ways they could have done this. Oh, shit. Guys, sorry. I was really getting into that there. Sorry, guys. Oh, my God. I just did that for like a couple of minutes there. The screen is money, and Sean is a Jew, therefore he won't share it. Okay, so they're saying that, look, all these things, they never did a good job of proving damages. They could have had things going on with it. They could have brought in the sponsor saying, yeah, this guy talked to me all the time. Instead, it's just Shoal Levy going, well, hey, I kvetched, and I had to talk to my guy all the time. Oh, and just, it was making my tuchus hurt all the time. So, but there's no medical documentation. You need that. Therefore, the court doesn't find testimony that plaintiffs suffered harm for 6 months after receiving the letter credible, nor was it so egregious a 5-figure damage award is warranted. Instead, an award of $5,000 is commensurate with the evidence presented in this case, in line with similar cases. There's a case of $1,500 where there were numerous calls to the plaintiff, awarding of $1,000 in similar circumstances, $2,000 in similar circumstances. So they cite a bunch of cases here about when they've done that. The reliance on this case, Coley versus Independent Recovery Resources or Reserve Incorporated, doesn't change the court's conclusion. In Coley, the defense attempted to collect a debt associated with the storage of embryos that were supposed to be destroyed. When the plaintiff refused to pay, the defendants made several false reports to the debt recording agencies, which resulted in derogatory notations and decreased your credit score. Here, defendants' misconduct was far less egregious than the purported debt was in contention, the housing rental fees, and the only action taken was to send a single threatening letter. Thus, the award, similar to $50,000 in Coley, is unwarranted. Accordingly, it's $8,000 in actual damages, the $3,000 fee, and the $5,000 in emotional damages. Now, the $187,000 in attorney's fees for 517.7 hours because it required extensive motion practice and a hearing. In response, the defendants contend this award should be reduced by 63% because the hours billed were excessive and much of the time expended was for filing a motion for default judgment that was ultimately denied. Well, yeah, but that's only denied because you showed up. And pursuing claims that were dismissed on summary judgment. Yeah. Manny Beat says, all I did was threaten prison. Yes. Also, yeah. I'm not going to tell you what to do, but just ignore people if they're riding your dick. But you're a big kid. I'll leave you alone. Anyways, going further, the act itself allows the prevailing party to obtain an award for the cost of the action to get the reasonable attorney's fees. The starting point of the calculation is a calculation of the lodestar. This is a very common word you'll hear when it comes to attorney's fees. The lodestar. By multiplying a reasonable hourly rate by the number of hours reasonably expended on litigation, the lodestar creates a presumptively reasonable fee. So this guy, this magistrate's going to come out with this. It's based on a reasonably hour rate. The rate a paying client would be willing to pay, bearing in mind that a client wishes to pay the least amount necessary to litigate the case effectively. So that's how they do this, chat. They're like, Well, what would a client pay? As little as fucking possible. Because that's the way the magistrate's saying, you guys are fucking cheapskates. But to be fair, as an attorney, my job is to do this as efficiently and as cost effectively as possible. So how do we get to this? So you have to do it's got to be in line with prevailing rates in the district where the court sits for similar services by lawyers of similar skill, expertise, and reputation. So the party seeking attorney's fees bear the burden of demonstrating the hours is reasonable. The amount of time expended is adequately supported by time records, where you got to document all your time. Finally, adjustments must be made to the number of hours expended based on case-specific factors, including deductions for excessive, redundant, or otherwise unnecessary hours. So the district court may look at its own familiarity with the case and its expertise generally, as well as the evidentiary submissions and arguments of the parties. So if you just submitted like basic bitch boilerplate work, the court's going to look at that. But if you submitted really well detailed, like brilliant fucking shit, the court's going to take note of that too. It's all about how you do this. Oh. So, as an initial matter, the court finds the requested hourly rates are reasonable under the circumstances. Plaintiff seeks to recover fees for 9 different timekeepers. And this is where I said, guys, it's all the staff, including 2 partners charging $4.50 an hour, 1 of counsel charging $3.25 an hour. Remember, guys, of counsel's like that independent contractor. He gets to put his name on the letterhead and all of that, but he's not part of your firm. 2 senior associates charging $3.25 an hour, 1 junior associate charging $200 per hour, 1 law graduate charging $150 per hour. That's somebody who passed the law school but has not taken the bar yet or is waiting on his bar results, and 2 paralegals charging $100 per hour. These rates are largely in line with prevailing market rates in this district for FDCPA litigation. Now think about it. That's for the Southern District of New York. So if you guys are out in like the Wyoming, it's going to be probably less. Or having this many people involved. You know, it really all depends where you're at. But yes, these weren't $1,000 an hour attorneys. This wasn't Alex Spiro. So they talk about hourly rates of $4.50 for partners and $3.25 for associates. Good. You know, they've approved this before. And there's probably some work that's been done by this law firm to make sure what is acceptable for the court. Notice these all match up, right? Well, it matches up down here because they've probably done the work and make sure we comply when they defend these actions so they can make money. However, the time expended and the number of timekeepers assigned to case is excessive. 517 hours by 6 different attorneys. It's a lot of fucking attorneys. While the case included motion practice, the overall subject matter is not complicated. And the hours far exceed the hours awarded in similar cases. So there's another case, 107 billable hours in a matter that should have been a routine claim, but for the defendant's insistence on litigating the matter aggressively. They say the court was not able to find, nor does the plaintiff identify, any recent case in this district where a court awarded over 400 hours of time spent in a straightforward FDCPA action. Moreover, much of the motion practice involved the pursuit of the New York state law claim, as well as the other claims that were dismissed on summary judgment. In addition, the plaintiffs seek to recover over 60 hours for an ill-fated default judgment motion. And they point out the extent of a plaintiff's success is a crucial factor in determining the proper amount of an award of attorney's fees. A reduction to account for the amount of extended on pursuing these claims is warranted. The court is mindful of the time plaintiff was forced to expend, but seeking an additional 48 grand for 107 hours of attorney time on a single brief on a single issue is disproportionate to the needs of the case. Okay, that is, as much as you guys want to make fun of Joe and everything, that is massive Jew action right there. Holy shit. 48 G's for one motion. $48,000 for a single brief. Not even a single motion. A brief that's a part of a motion. Woo. Woo. Take your shot. I get it. But goddamn, remember, guys, pigs get fat, hogs get slaughtered. But geez, they had to have known that was going to get. They had to have known they were going to take a haircut. To account for counsel's inflated billing practices. Now that's a sign the court's like, you guys are full of shit. In pursuit of unsuccessful claims, the court will apply a 45% reduction to the amount requested. When a court concludes the number of hours have been excessive, it may forego reviewing the individual entries instead of apply an across-the-board percentage reduction. So the court isn't forced to go through line item by line item. They could be like, wow, that's way too fucking much. You get half. So there you go. That is the findings of it. So instead, there's $103,214 in attorney's fees. The cost, $5,900 in cost. There's no argument offered in opposition. In addition, reasonable attorney's fees, the prevailing party is entitled to cost of the action. Yep. Here, plaintiff submitted an itemized breakdown of the costs incurred, which are administrative fees for court filings, ordering transcripts, and conducting legal research, meaning using LexisNexis or Westlaw. That's a separate thing, because with LexisNexis or Westlaw, chat, that shit is by click. By search, they charge you for clicking around. It's a fucking ripoff. That's why I use a kind of like an oldie version of one of Lexis products. But yeah, like fucking like pro grade LexisNexis is a fucking scam. It's powerful. It's like being God. But that shit is insane. Nisa Natick, we'll get to that. That's a good question. So given the length of the case and the number of filings, this all makes sense. That's a fair amount for a case like this. So you get $5,900 in cost. So you add it all up, $8 grand plus 500 in damages, plus 103,214.37 cents, $5,924.87 in cost for a total award of $117,639.24. So ultimately, this was done by the magistrate, which then moves us on to, chat, the opinion and order by the judge himself. And this is just him surmising because nobody objected. No objections were filed. So that was done July 3rd. This is done September 24th. Who is messaging me? Oh. So anyways, getting through all of this and what occurred, now defending for the court is the report and recommendations by the magistrate judge. And this is where they go through all of this. The defendants made no objections to the report and recommendations for the following reasons. The court adopts it and awards it for a total amount of $117,639.24. They go through the background. It skips through all of that. We get through all the things here. Standards of review. The court may accept, reject, or modify the findings made by a magistrate judge. That's true for every judge. He can get most judges, though, to be fair, guys, Here's how it works. Judges hire the magistrates because they're going to hire people who are like, you think like me, you're going to do what I would do. So usually when you appeal a magistrate's decision, here's what happens. The judge goes, he'll look at it and you go, he'll go, yeah, my magistrate's good. Fuck you. Judgment affirmed. So happens all the time. Happens all the time. So parties may raise specific written objections to the report within 14 days of being served a copy of the report. Okay, well, when nobody submits an objection or any portion thereof, the court reviews the report for clear error. And he's like, I'll take a look at it. If there's nothing wrong, there's no clear error on the face of the record that you can find. So the R&R was issued July 3rd. After requesting an extension, the defendants had until July 31st to file objections. They filed none. Since there's no objections, the court reviews it for clear error, and there's no clear error. So, as expressed more fully in the R&R after considering the evidence, the magistrate made the decision about all that for the total award of $117,639.24. For these reasons, the court adopts the R&R in its entirety, directs the clerk of court to enter judgment as follows for a total of $117,639.24. The clerk's also directed to close this case. Dated September 24th in White Plains, New York. By Nelson Roman, United States District Court Judge. The end, chat, and that's where we are now. That's where we are now. Oh. Once again, guys, like I said, it's an issue. A little problem becomes a big problem. You know, paying that $3,000 retainer fee at the beginning, plus like, hey, here's $3,000. Here, how much was your attorneys? $3,000, cool. Here's $1,500 to fuck off. Guy may have taken that and walked away. Let's say he says, no, I want $8,000. You know what? At the end of the day, it'd have been cheaper just to go, wait, how much is that? 8,000? All right. You know, here you go. Fuck off. It's just, yeah, this was, you know, it's just like, oh, well, we fucked up. We'll fix it. You know, settlements are generally cheaper, guys. So, now, like I said, now that we've gone through all this, you know, there's a lot of issues. Now that I hope you guys have seen this, everybody before is like, oh, fuck, Joey's completely fucked. No. I mean, this guy admits, like, yeah, I got kicked out of my apartment and I was locked out and all my shit was gone. Sounds like you got evicted. Sounds like you owed rent. So it does sound like there was something there, but it's not found. So since that's all in contention, it's not clear that it's fake. Do I think that the fact you can't verify any of this and all this shit happened out of state and we normally never ever do this stuff, this was a massive, like, everything failed that we normally do, we didn't do? Yeah. This is, I don't know why you didn't settle, man. This is crazy. I don't know why you didn't settle. Bermain says Levy got evicted of 109 apartments. Yes, he's now working on 110. Oh. But yeah, this is just, this is why you generally, little problems stay little problems if you take care of them early. Little problems become big problems if you ignore them or don't deal with them. You have to deal with them at some point. So there you go. So, the one question I did want to ask here, Nisa Natick brings up a great question. Does it mean that Shul Levy's on the hook for the 80 grand? No. Nope. It's not his problem. They took this case, his attorneys took that case because they get attorney's fees. That was whale hunting. They took that case on contingency. They wanted the attorney's fees. They can't go on demand he gets that money. That's not his problem. Theoretically, could a client sign a contract like that? God, yes, they could, but I'm sure whatever state bar would be involved would be like, yeah, you ain't fucking doing that, chief. So no, he's they're good to go. But that's a very good question. Actually, very, very good question. Thank you for asking it. All right, so we got to catch up on some other comments here, guys. So we're going to get to these. Michael says for 15 Malaysian ringgit, is saying my experience is debt collectors will just sell your debt onwards if you contest it because it's no longer worth it if you'll fight it. Sometimes that's true. Sometimes it's not. I can't like I said, I don't give financial advice, but that sometimes may work. Dead-Eyed Elvis for $20. Thank you, by the way, for the super chat. Saying Joe did an enforcer oopsie, and he knocked up April. Oh. Lawler Scooty, no, I've heard the rumors too. I'm not going to indulge in those. That's true speculation. I won't do that. Philip Coggins says, you and Nick explaining who Jack Murphy was is still one of the funniest things I have ever seen. I remember that. I remember those days. Oh, just like the Smiths song, And heaven knows I'm miserable now. I can't sing like Morrissey can do, though. That's... Ambo's Currency says the FDCPA is important because in the past they could blow up your pager. That's what happened in Lebanon. They all owed debt, and the Mossad called it in. Oh. Yes. And Meme Copium. Oh my gosh, you are here, you bastard. He did a show this morning, which is very interesting. Josh, you did a great job. But yes, sometimes when you look into the Jack Murphy looks into you. Yes. Yes. Maddie B says I should be a law professor. No, I shouldn't. I appreciate that, but no. J-Rock, way too much academic research you have to do. J-Rock says J-Rock gifted 5 subs. Then he gifted 5 more for 10 subs. And then Amateur Iconoclast gifted 5 subs. Philip Kogan has been a member for 4 months. Says if they shoot your dog, would that make them the ATF? It might. Then SB Sellers gifted 5 subs. Thank you. Maddie B says $2 the dues for local 127. Yes, apparently the Greens are unionizing out there. So Malcolm Combs for $2 says, are there certified debt collecting masters? Yeah. The J-Rock gifted 5 more subs. Thank you, J-Rock. Toger is saying, assimilated or sucked into the fat flap abyss of my elbow. I mean, maybe it happened, but it can't be worse than the draw your mom's fupa's got. Cat Madison gifted 5 subs. Thank you, Cat. Thank you for the support. And Blade 2.0. When you with a name like that, you're like, it's the regular types of knives are Blade 1.0. What we bring to you at Blade Co. is Blade 2.0. It's a knife, but better. Gifted 5 subs. Thank you so much for this. Thank you so much for the support. I hope that's when I see that like Blade 2.0, you're like, it's a blade, it's a knife, but knifier. Oh. Jamie Mooley says, did you hear about lead attorney? Yes, I did. Like I said, my prayers go out to him. I wish him nothing but the best. I know he said he's only they looking at 5 years. I hope it's 50 more. Whatever it is, I hope he beats it. Hope he can get on top of it. Seek a loader for 10 Singaporean dollars. Says, is this a misappropriation of client's money? Logic did his own share of Baldo guarding, didn't he? But never did I expect he would disbarred first before Ricada. Like I said, guys, he's not going to get disbarred. Like, if this was all fake, yes. But remember, there's enough here now. Like I told you guys, I was trying to point out, like, it can kind of go both ways. And why was I trying to do that? I didn't want to spoil. Look, when you see this, there's like, it's not clear. It's not 100% clear. Nicholas Kreuzer is saying Jew PvP is enabled. Yes. Friendly fires off, chat. Bob Masavo says it was also during Kwanzaa. Ooh, that's even worse. Michael James says, could you read his deposition next? I've read parts of it. I've read the clips that are on the farms, guys. I would not want to do that tonight. I am tired. We'll do that another day. But we'll keep that in mind. Oh. Reformed Convict, good to see you, man. Hope you're doing well. Says, as an addict, blaming someone else for your relapse is complete and utter bullshit. It's your fault. You're an addict. It's a victim junkie mentality. It's not my fault. He doesn't take any blame in his life. Yeah, it sounds like that a little bit, and I understand that mindset there. Michelle says, I worked for a bitch attorney in the middle of nowhere, Wyoming. Her rates were astronomical for the region. You can see that depending on the situation. J-Rock gifted 5 more subs. Thank you, J-Rock. Palmyra Productions gifted 5 subs. Thank you. Thank you guys for your support. Take Rat says, LOL, I had a debt collection law firm call me from Minnesota. Yes. If you don't pay this debt, we'll make you put on the Baldo, sir. We'll make you come to a deposition. You'll have to wear it. I asked the last date of payment 8 years ago. I told him Arizona law says nope, statute of limitations. And that's true. There are ways where if you call them and you point that out, yeah, they're collecting zombie debt. They're collecting debt in the hopes you're a sucker and you'll pay up on it. But they also have debt that's valid. You just got to check. Nick Kreuzer gifted 5 subs. J-Rock for 5 more. Thank you, J-Rock. And Squinting Cat for 5 more subs. Thank you. And speaking of that, come here, buddy. Hey. Hi, Clyde. Come here. You being a little sleepy boy? Come here, Clyde. Clyde just told you guys all to fuck off again. So come here, Bubba. Come here. Yeah, he's just eating food and getting yelled at for going outside and barking. Oh, well. President-elect Phil Swift, why are you making me fucking do this? God, why? Fucking why would you do this to me? God, why would you do this to me? Congrats to Nick and April on their first child. Fuck. So. Cyanide Cologne says there's a 2-year statute on collections in British Columbia. So people move to British Columbia who fuck up and end up in debt from elsewhere. Interesting. Proof of life for Clyde Brooks. I'm trying to work on that. Had a debt collector call my house looking for someone with the same last name. They didn't believe that you were telling them the truth. Yeah, happens all the time. Last Imperial says, can we have a month to celebrate Grays on this channel? Not in a million fucking years will we celebrate Grays. Never. Palmyra Productions with 5 more subs. Thank you. Thank you. Oh. I got to go on an Ozempic diet. We need your legal analysis for years to come. Oh, thank you. Oh. Is the kid thing real? No. Sullivan says, I will never turn off ad block on Sean's channel. Well, thank you. I appreciate that. Okay, so what's my take on Warhammer 40K? Well, what I mean, what else can you say about it? It's fucking amazing. 40K is one of the coolest things out there. I remember as a kid, like I remember being in like Best Buy and I'm like looking at the 40K game that was up there in the computer section, and I was between that and buying some game where it was like World War One never ended, and it was like 1964, and the guy's like, the dude Best Buy dude was like, this is back when like they were cool dudes. He's like, hey man, don't buy that. That sucks. He's like, that other one you picked up, that's some good shit. And I'm like 12 years old, and I'm like, all right, we'll buy that. I bought that, and I bought like, oh god, what our Warhammer game it was. I don't remember now which Dawn of War it was, but I was like, fuck yeah, this is cool. It was great. I love it. I don't have miniatures. I might start trying to figure out if I could 3D print some, but it'd be fun to paint them again. I painted a couple of them, but it sucked because they were so small. That's a shame. Says, can't the Grays share a month with the Blacks? No, they don't even rate a month. That's how low they are. That's how low they are. That's how low they are. I thought I heard Clyde clicking around in here. That's how low the Grays are. Oh. Space Marine 1 was very good, yes. And I've heard Space Marine 2 is really, really good. I have not gotten to it yet. I will say all the people that have been playing it have fucking loved it. So that tells me a lot. The Merchant says 40K would be cool if the Imperium didn't get all the fucking attention. It's the main character. I fucking hate the Imperium so much. So boring. Well, like what? Are you like a Tau supporter? The space commies? Or the Necrons? Like a bunch of gay robots? No. It's always for the Emperor. For the Golden Throne. May it shine for another 40,000 years. Hopefully Henry Cavill doesn't back out of 40K. Yeah, I know. That'd be very cool. Do I like the Death Corps of Krieg? Yes, I do. I think that's a pretty cool story with them. Although the funny thing is everybody's like, oh my God, they're dressed like the Germans. No, it's actually more stylized on the French than anybody else. The Feldspaten thing, yeah, is German, but yeah. Greys are lucky to still draw breath. Yes. Also getting back to the Death Corps, though, I mean, the Cadian Guard, though, is better. I mean, the planet broke before the Guard did. It's always impressive. Nick Kreuzer is saying, I've been loving the heck out of the computer RPG they made, Rogue Trader. It's pretty fucking awesome. Haven't played any of that. Nicole says, your favorite army? Do I read the books? I've read like one or two of the books over my time, but I haven't read a lot of them. But I've read up on the lore. The lore is really fucking cool. You learn a lot of the lore, a lot of the story. But as far as like, if I had to pick, like obviously I like, what better part of the pyramid you get to be for the Emperor? Actually, it's 2 point. Hold on. Hey, honey, are you up? Okay, good. I won't wake you if I say this. But you can be for the Emperor! What's not to love? No, but I mean, like, there's some great things out there. I'm not gonna lie. I like the Ultramarines because they're blue. It's my favorite color. So I am a Smurf fan at the end of the day. But there's all kinds of funny ones out there. Like, I like the Rage Marines. I always think that's fun. And they got the electrified chair. If you guys have never seen that they're they are a chapter out there that's been made up. They're fucking hilarious. The wolves of Fenris, the Fenrisian wolves. You can't like the space wolves; they're kind of cool. But like the Black Templars are pretty cool. And then obviously there's the other stuff out there, like the Death Watch, and then you've got like the Custodes. I know that's Henry Cavill's group. Is like, I like being Custodes. It's like, yeah. So, hope that answered your question. The Warhammer video game was best for the Necrons. Yeah, I don't think I played them as the Necrons too much. I mean, when I was playing like Warhammer and all that shit on the computer all the time, I was also playing the shit out of Operation Flashpoint, which, if you guys don't know what that is, that was Battlefield before Battlefield was big. It was fucking dope. If you guys know what Arma is now, or like DayZ, that's, I played the progenitor of that all. I played the proto version of it. Joe Loy for £10 sterling. The King Sterling says, love you in 2.0. That lady keeps me based. She does a lot more than that. She keeps me, she keeps me grounded. She keeps me humble. She's not afraid to tell me when I'm getting out over my skis, or I'm pushing things, or acting like a dick, or I need to rein stuff in. I'm very fortunate in that regard. In addition, that she loves me and puts up with me and truly cares about me. Like, it's all a bonus. It's all a bonus, believe it or not. Let me see here. What do you guys... Oh, hold on, chat. We gotta open up something that somebody sent in. I don't know if they're here in chat, but I gotta go grab it because it came in the mail today. So hold on, I'll be right back. What are we gonna run for a second here? You guys can watch for like 20 seconds. Yeah, here we go. Here we go.
We know we're under attack. We know it. We're breaking the conditioning. We're coming for you, globalist. Coming for you. Coming for you. We know what you're doing.
Come here, buddy. Clyde. Hey, come here, Clyde. Come on. Come here. Clyde, come here. Come here, buddy. Come on. All right, whatever. Okay. All right. All right, guys. So, you can always send me things to the P.O. box, and somebody sent me something from Amazon, so let's see what it is. What's in the bag? I don't know what's in the bag. That's why we're finding out together. Why is this not working? Pull it open. I'm pulling it open. I'm trying not to get all that fucking fluffy shit everywhere. Oh, there we go. Oh. Ooh, hello. Okay, well, there's nothing in there. All right, just want to make sure. So this is cool. I've never got to do one of these before. No, it's not a medallion, chat. It's a Gundam. Never built one before. So this will be fun. This will be a lot of fun. Never done Gunpla before. Looking forward to it. Yup, it's a ball, though. Yes. Oh. Flash starts crying. Cyanide Colosis, don't do anime, Sean. It gives you cancer. Yeah, I mean, like, I would like, well, there's some things like I do, like, like in like Macross, the little fighter planes they have, like before they turn into the guys, but when they're in like fighter plane mode, I always thought, like, I don't know if they do models of those, but I always thought those would be cool to make. What is Flash Cry? Does he not like Gundam or something? Ellie Fan says, what's a Gundam? Okay, so do you remember, okay, so this is a massive fucking robot that's piloted by people inside of it in space, and they fight. There, that's basically what Gundams are. So, oh, Runkle, yes, Runkle here is helping out. Runkle says if anyone wants to send him a Sunichu medallion, his address is care of the Office of the Prime Minister, 80 Wellington Street, Ottawa, Ontario, K1A0A2. And notice, because I said it, Runkle did not, the RCMP is going to come to my door. Oh. Elliot, oh, hold on. What J Rock are you saying? Imagine if a train could become a robot like Sean does. Jesus. Oh my God, you guys are being ridiculous. You guys are being ridiculous here. Yeah, a Gudred's 100-foot tall battle robot that someone pilots. Yeah. Basically, it's kind of like Power Rangers when they form Megazord, except it's like one person at a time. Oh. Whew. So what are we doing here? Hold on. There's one thing. Oh, I need to fix. I forgot to include. And if you guys, if anybody here feels like sending me something in the mail, even things that tick, I'm okay with. If you guys send it to the PO box below, I'll be sure to open it on stream. So it should be down there below if you guys want to take a look. Yes, Gundam is like Power Rangers until they start nuking orbital bases. Yeah, like there's all kinds of death and destruction in the Gundam series. What's in the movie where Idris Elba, where the creatures come up from the ocean? Oh, Pacific Rim. Yeah, that was like, I didn't understand that movie. I thought it was gay. So I thought it was ridiculous. Solon says, 8th MS Team is my favorite Gundam series. I have no idea what I am a fucking casual. I have no idea what any of that means. Sorry. I'll get 10 Sonichu medallions next week, and I will drop them all off at the Diocese of Cleveland, and they will fucking get exercised, and I will never touch them. My nerd cred is draining away in front of your eyes. Oh, no. The 8th multiple sclerosis team. That's what I assume it means, but I don't care if my nerd stuff is falling away from your eyes. I do enough nerd shit on my own. I don't need your validation. Also, people are wondering, I did get the Dauntless put together, and I did get the cockpit all set up. I mean, check. Hold on here. Where's the light? Where's the light? Here we go. We did pretty good on this, chat. Look at that. Look at that. You know, it's pretty good. Like, you can see the insides. Did a great job. Oh. I'm sending you a ticking package with medallions. Fine. Like I said, if you're going to send me something ticking, chat, make sure it works. I don't want to walk away from it. Do it right. You know, if Uncle Ted give you a recipe, double it. I'm a big boy. I'll take seconds. How much to put on the medallion? None. Nothing. I will not damn myself with it. Weird. That was weird. What the fuck happened there? Everything just like crashed out. Yes, a Baldo's $80. Yes, and I thought it'd be funny because you can download on 3D print one of the 37 millimeter launchers. It's about the same diameter. It's pretty close. I was doing the math on it. Like, you can launch them out of a 40 millimeter launcher. I think they'll do 37 millimeter launchers. Okay. And get one of those handheld 37 millimeter launchers, 3D printed up, and shoot Baldos out of it. That'd be funny. It'd be like the best less lethal round ever. A big old rubber Baldo hitting people in the face, or just shooting the rubber rings out at people. That'd be kind of fun. Baldo buckshot. Pyrometer says, Sean, I am hot premium woman from Bulgaria. I have 500 pagers. Most premium pagers. Thank you. I'll take a look at them. Hey, Clyde took over the stream. Oh. Knuckles says, I've considered making a Baldo gun. I've really thought about it. I think it'd be fucking hilarious to take it to a range and like a 40 millimeter launcher and load it up and to like pull a chalk around and shove a Baldo in it and shoot it like at an oil drum. I want to see if it'll dent it. I think it'd be so damn funny. I think it would be absolutely amazing. Nick Kreuzer says, for the Imperium, for the Emperor. Confused yet loyal orc. Yes. As long as you believe, it works. That is the coolest thing about the orcs. They just take like a ball of like wire and shove it in the engine compartment of a truck and it runs. Why? Because they believe. President-elect Phil Swift says, which month matters more for modern leftists? February or June? You can't say every month matters challenge. Impossible. That's a funny one. I like that. Maximilian for $5 says, please play the 49-second YouTube video for Uncle Doran's heroic defense of the Siege of Terra. I know, that's the one with Alex Jones in it, isn't it? With him and Joe Rogan. I love that where he's explained they're both Joe Rogan's a guardsman and Alex Jones is an Astartes. That one's great. Reformed Convict says, Uncle Ted would find sending Sonichu medallions as being a bitch move. I hope he mails Chris Chan a package. Thanks for the entertainment. Well, Uncle Ted's up in the bomb factory up in the sky, so sadly, may he rest in peace. But yes, he would detest the medallions. Nick Kreuzer says, what the Israeli elites don't want you to know is the pagers at the store are free. I have 158 pagers in my house. Oh no, that's not good. Oh, you guys think Joe's hold on here. We'll bring it up. I forget who's who in that. It's been a little while since I've seen it. Let's see. Oh, wow. Bruce Rivers is already talking about Garth Brooks. 23,000 people watch it. Holy shit. People really care about that one. They really give a shit about him possibly doing that stuff. Interesting. Yeah. All right. Here we go. Here we go. If you guys, let's see what it's. Yeah. Here we go. This is my favorite one of these Alex Jones things.
I feel like they're at war.
I think when you jump to the next level, there's an even bigger war going on.
What's the biggest war?
Psychological stuff. No one knows the truth because it's virtual reality once you get to that level. So no one knows.
Seems to be like a universal struggle.
It's all mind war.
I wanted people to be able to see it.
I just don't think people are ready for it.
Well, sure.
The third dimension is just this empty wasteland. Above it and below it is all this incredibly complex stuff, but our brains tune all of it out because we can't handle it.
It's almost like there's too many things happening.
People go nuts.
For people who are not thinking the way you're thinking, it can be exhausting.
And the truth is, no energy is ever destroyed. It all continues on.
You were telling me that it fucks with your head. The certain amount of it, after a while, it just fucks with your head.
That's why I'm usually kind of like almost autistic, is I'm just being constantly.
Right. Why?
Because lower entities will come in and violate your free will.
They know all your bullshit. They see right through you.
They will not manipulate your free will unless you ask them in.
I have.
Dude, do not say that. I'm going to get killed.
I've 100% communicated with something.
I'm not judging anybody. I'm just saying, be careful.
The question is whether that something was actually in my imagination or in my mind, or that something was something that takes place in another dimension.
Once you open that gate, it's all bad.
Why is it all bad? Why can't you experience that interdimensional being and learn something from it and be a better person when you come out of it?
Because every time it gets control, it starts murdering everybody.
They wind up killing everybody.
In every case. And it always starts beautiful. It always starts great.
Problem is, some of it makes sense.
That's where the psychosis comes in.
Whoa.
It's going to create a giant societal crisis where most of the people are already going to get killed because an evil force wants conflict. I'm saying no, no, no.
It's all chaos.
Stop it.
This is the new.
Oh, that's good. It's a mind war. Yes, it's a mind war. Yes. All right. Well, anyways, guys, and I think we're going to wrap it up here. We got to land the plane. It's been 3.5 hours. Like I said, I know a lot of people were wondering, what does all this stuff mean for Joe? It just means he owes $117,000 judgment. Once again, this is one of those times where, like, if you work on something small problems stay small if you address them. When they get out of control, then they become big problems. Like, and all the people are like, oh, they're just barred. It's like, nope, not happening. Chill your shit out. Because there are a lot of unanswered questions that don't make any sense at all. So just trying to tell you guys, chill out. Say, Runkle, did you say you're leaving? We'll have to, oh, no, somebody said they're leaving you. Okay. Yeah, Runkle, we're going to have to sit down. Like, we'll have to work on that. Trying to figure out, like, how to do the Baldo stuff. Because, like, I got the 37, well, I don't know. Can you do a 37? Well, you can't 3D print up there. Well, if you get your machine gun license, can you print a gun? Because if you can, I've got the thing where you could print the 37 millimeter like shot cups. And then from there, you can make like a Baldo loading. That would be fun. Yeah, I'm still here. Good. And like I said, guys, this is getting back to the whole thing on that. Oh, you're already working on that. I'm going to have to reach out to you then. We really got to figure this out one night. Yeah, this is kind of this is sketchy fucking behavior. But like this whole thing is so fucked up, and it shouldn't be this fucked up. This is unnecessarily retarded, unnecessarily complex, unnecessarily sketchy and scummy. Didn't have to be this way. They can't 3D print in Canada. I don't think. Well, you can have a 3D printer, but you can't 3D print gun stuff. I think you have to be careful. Aren't all lawyers sketchy? In one way or another, we are, yeah. You need an SNC leveling contract from liberals to 3D print in Canada. Oh, and I get that joke. Does Joe know I'm covering this? I mean, well, no. I'm like, I don't tell people or ask their permission for stuff. So, yeah, I should read his deposition. Well, that's the thing. I have not read the whole thing, and I didn't get a chance to read through all the declarations. I kind of stuck with the major relevant documents because those point out the relevant major things. So, oh, Dagamore, I know I can print a 3D print. I got my fucking 3D printer sitting right here. I can print anything I want. I was talking about Runkle being in Canada. I know at first people were all screaming like, oh my God, Joe's doing this, that, and the other. It's like, doesn't really look like it. Remember how I said at the beginning, if all that stuff is wrong, then yeah, he's in trouble. But remember, I say if. And I'd say, let's get to the end. And now what do we see? It's not really clear. And it sounds like this Levy guy is a sketchy rat motherfucker. So. Oh, you have to get the license for printing 3D pew-pews. There we go. Okay, I didn't realize I required a separate license, but yeah, there's some pretty cool launchers on Odyssey. All right, guys, so that's it. Yeah, we're landing the plane. We are done here for the night. I'm not sure what we're going to get into tomorrow. We might watch Sarah Boone a little bit tomorrow. We might do some model stuff tomorrow. Like I said, we got the Dauntless we're working on. We're chugging along on this bad boy. Work on putting him together. Maybe get it primed up and get the dive flaps on, stuff like that, and go forward. So that's it, guys. I will see you around. If you guys are new, please like, subscribe. We do a show every Thursday night. We cover all kinds of fun shit. We'll be back to that on Thursday as well. So hope to see you around. And we're doing stuff all the time. Sarah Boone, she shoved her boyfriend in a case that suffocated him. She starts trial next week. Monday there's nothing to do because it's jury selection. But we'll be watching it throughout the week when I'm available and my schedule allows it. So the other thing we're doing, guys, is locals. If you guys, locals, it's like Patreon, but not as gay and not run by faggot communists. Just run by gay guys like Dave Rubin, who might be Russian assets. If you join, you can get 1 month free with Pot Cream. You get access to all the live shows we do, 2 a week. It's a lot of fun. So with that being said, guys, I will see you next time. And remember, just because you did it doesn't mean you're guilty. Although, Jesus Christ, Joe, buddy, man, this wasn't good. Like, you could have nipped this one in the bud a long time ago. Like I said earlier at the beginning, for want of a horseshoe nail, a kingdom was lost. So, good night, everybody.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney.